গোটা বইটার
নে,
রাখলেই ভালো।
yes, mention.
For inclusion, my lord, application.
Yes.
For
Hand over.
this was hearing, my lord.
Yes, hand over.
But for inclusion, this was fixed on 11th of
What is this
November.
hearing?
This is application.
Hand over.
I'm so grateful.
Application, your lordship.
Yes.
Application.
Yes, hearing slip.
My lord,
Because you're almost.
application for inclusion.
Hand over.
Hearing a lot.
Yes, hand over.
My lord, application. Application. Application.
Application for inclusion.
My lord, may I be permitted to mention a matter? My lord, this appeal was filed pursuant to Honorable Supreme Court jurisdiction. It was on the last occasion, my lord, this court
Supreme Court directed to file an appeal.
give me the liberty, my lord, to
Yes.
file this appeal. My lord, on the last occasion, it was directed that this matter shall appear today under the hearing for the heading for hearing.
Not
I have the order,
applicable.
my lords.
Please hand over another slip. We'll ensure that it comes.
It's the mentioning slip. It's the order, my lord.
They can even hearing.
Great.
Yes, as soon as the file comes. Yes.
For the defendant 1 to 3 of the
Yeah.
apparel, the paper is ready. But in the, I checked up the record. No, the defendant's document, exhibit A, B, C,
Defendant are the appellants.
defendant 1 to 3. There are 4 defendants.
Right.
The suit is the principal purpose of contract. Now it appears on the report also, exhibit A, B, C of defendant's document. The Xerox copy original document has been taken withdrawn by the defendant 1 to 3, our client, by keeping a Xerox copy.
Yes.
But that has not been returned back.
So what do you propose to do?
That is up to your lordship. My paper is ready.
What is the application for?
Your lordship, we had filed the application. I am for the defendant number 1, your lordship, because they were enjoying a injunction restraining order since 2016. They did not file paper book only after we filed the application that the interim order may be, but they have not served me. They have not served the paper book.
That is in the department.
We are asking both of you, is it possible to take up the appeal for hearing without those originals? I mean, something hinges on those originals. Are the veracity of those documents challenged by them?
It because the defendant number 4 sold the property to our client.
True copies are
Your
part
lordship,
of the
true
paper.
copies are there.
Copies are there.
Nobody is
So there
disputing.
is no challenge to the signature.
No,
So then we'll take
Yes,
the appeal
yes,
for
lordship.
hearing. Please serve paper books.
The
within-
paper we have it is in the department. 6 copies.
Your lordship, I'll take it from
Contact
the
the department and they'll give.
Yes.
We'll pass a direction and we'll keep the matter next week for hearing.
Your lordship, it may appear in the December so that we can get ready with the.
The records are have come and everything else.
Yes, everything. I have checked up the record.
Well, at all. Learned counsel for the parties submit that the appeal is otherwise ready for hearing and can be taken up. Full stop. What is the application for vacating?
Your lordship, vacating and for there are 2 applications.
For vacating other?
One for that we may file the paper book, liberty may be, both may be disposed
Next
of.
para. The applications bearing Can 3 of 2019 and Can 4 of 2022 are respectively for Can 3 is the injunction.
Your lordship, Can 3 was that we may file the paper book, and Can 4 was that the order may be vacated because they have not filed.
Full stop. Next para. Can 3 of 2019 is an application by the respondents seeking leave to file paper books in view of the appellants having not prepared the same. Full stop. However, comma, it transpires that the appellants have in the meantime filed the paper books in the department. Full stop. Next para. Insofar as Can 4 of 2022 is concerned, the same is for vacating of an order of injunction passed in connection with the appeal. Full stop. Since the appeal is otherwise ready for hearing, comma, let the same be fixed for hearing on same be listed for hearing in the monthly list of December 2024. Full stop. Next para. Can 3 of 2019 is disposed of in view of the appellants having already filed the paper book. Full stop. Since the appeal itself is being fixed for hearing, comma, there is no useful purpose would be served in vacating the injunction application, which has been subsisting since long, comma, at this juncture. Full stop. Accordingly, Can 4 of 2022 is also disposed of accordingly. Full stop. The department shall serve copies of the paper book on the respondent's advocate as and when so approached by the said learned advocate.
Obliged.
Two, I make it.
Yes, Mr. Bhattacharya, what is the
The
application?
application was still the suit for partition, my lord. The
Suit for
challenge the preliminary.
Why so long after appeal is of?
I have not yet filed half the copy of the application. There are so many respondents, 20 respondents. I have not yet served.
This is, you're moving it for the first time.
Therefore, that because the applicant number one originally she died, that application of substitution was filed. That has been allowed within time. my lord.
So 39 opposite parties are there.
Yes, yes.
You have to serve.
I have to that.
You have come up against a preliminary degree.
It-
Can 2 of 2021 is an application for stay of all further proceedings in the suit. Full stop. Next para. The petitioners shall serve copies of the said application on the respondent stroke opposite parties, indicating that the matter shall be that the application shall be listed for hearing in the monthly list of December 2024. Full stop. Next para. Since the appeal has been preferred against a preliminary decree of partition, comma, the trial court shall proceed with the final decree proceedings. Push up, however, comma, no final decree shall be drawn up till disposal of the application. The petitioner shall serve shall file affidavit of service on the next returnable date.
Attempt 3 and 4.
No application is there.
Milord, application is not pending, Milord. Milord,
Not pending.
perhaps not.
Perhaps
Milord,
not.
problem is, Milord,
Appeal is ready for hearing.
I have misplaced, Milord, the paper book, Milord. Milord, there are two appeals. One, Milord, the probate application has been allowed. From that, one appeal has been preferred, and
That is your appeal.
that and both, and another is the rejection of my revocation application, revocation of probate.
So both appeals are yours. So appeals are otherwise ready for hearing.
Otherwise, ready for
Who is appealing for your other side?
Miss Dotto, Milord.
Mr. Mukherjee,
Sure.
Probal Mukherjee,
Yes,
Sheboti Dotto. Yes.
Sheboti Devo Dotto, Milord.
Ms. Dotto, can you serve a copy of the paper book?
Used to appear, Your Lordship. The client has instructed us not to appear anymore.
Do you have the paper book still?
If I have, my lord, I shall ask my client to provide him.
When the matter is called on for hearing, comma, learned counsel for the appellant submits that there is no pending application. Full stop. However, comma, the appeals are ready for hearing. Full stop. Learned counsel for the appellant candidly submits that the paper book has been misplaced from his office. Full stop. Next para. Learned counsel, the learned advocate, and we are not recording Mr. Mukherjee's name then because he will not be. Learned advocate, the learned advocate appearing for the respondent submits that the respondents have instructed them not to appear further on behalf of the respondents in the matter. Full stop. Next para. However, comma, the learned advocate na kore learned senior counsel. Full stop. However, comma, in the event the learned advocates for the respondents have respondents still retain a copy of the paper books, comma, a copy thereof may be served on the learned advocate for the appellants at the latter's cost. Full stop. Next para. The appellants shall serve a notice on the respondents directly indicating that the appeal shall be listed for hearing in the monthly list of December 2024. We have recorded that you have.
I received not a text message from the client yesterday that we did not appear in this.
We have recorded.
I'm grateful.
Okay, the paper book is
If you have a paper book, just give it.
Definitely.
Take Mr. Mukherjee's paper book, Mr. Bhattacharya.
Yes, yes.
So you'll get the points there. Yes, column.
Attempt
Five.
5.
Lord, I am appealing on behalf of the appellant. Lord,
Yes,
I'm
yes.
extremely sorry, Lord,
Why?
that on the last day, Lord, on 7th, Lord,
You did not appear. Yes, yes. Last chance.
and
Oh, it was dismissed for default.
my Lord, I apologize before Lordship that
No question of that. But you have
Oh.
this is an registration application.
this is an application, Lord.
But subject to the condition that you have to move the appeal.
Lord, I'm always
We'll keep it on Monday. Yeah.
not Monday, Lord, 1 week's time. Let me get because I'm in the midst of
Registration,
some
have
other-
you served a copy on the other
Lord,
side?
Lord, I have sent, none is appearing, but though I have sent it, Lord.
Very well. At order, but you'll have to file that receipt then.
And yes, appellate service, Lord, it has been made ready in course of.
Very well.
It
On
has
the
been made
pre-
ready, but since
On the prayer of learned counsel for the petitioner, the petitioner is directed to file affidavit of service during the course of the day.
Lord.
Pushed up, it transpires that a copy of the application has been sent to the respondents. Pushed up in any event, the respondents were also absent when the appeal was dismissed for default. Pushed up, accordingly, Can 6 of 2024 is taken up for hearing without further notice on the respondents. Pushed up, being satisfied of sufficient reasons for the absence of the appellant on the relevant date, Can 6 of 2024 is allowed, thereby recalling the order dated November 7, 2024 and restoring FA 14 of 2020 to its original file and number. The appeal is otherwise ready for hearing.
My Lord, yes.
Yes, everything. Pushed up, the appeal shall now be listed for hearing on November 20, 2024.
My Lord, I'm extremely sorry.
No. Please come prepared with the appeal so that we can test.
Much.
And if you can give a notice to the other side's advocate, if you can get hold of it.
Again, I'll serve. Again, this order
Yes,
will be
so that we can take up the
Yes,
appeal and
again,
dispose of. If
this
they're
order
not
will be
there, then we'll dispose of it.
so that they're not taken aback that the matter has been.
Yes, again they'll file a restoration recall application.
Appeal service technically.
My Lord, Mr. Shivashish Chatterjee is appearing in this matter on behalf of the appellant.
Yes,
I am appealing for this one.
yes.
My Lord,
Please take the microphone, ma'am.
my Lord, this is a no objection brief, and
So what? But you
my
take the
Lord,
no objection.
I am instructed to pray for 2 days accommodation only.
No. What is the application for?
Application for stay in a money degree. This is
My
a
Lord-
fight between the mother-in-law and the daughter-in-law. Son died.
My Lord, he has.
I am from the mother-in-law.
My Lord, he has some personal difficulties. That's why.
When should he keep it then?
Sorry, my Lord.
When should he keep the matter?
My Lord, only 2 days accommodation I am praying for.
2 days means today and tomorrow.
Yes, my Lord.
Then we have to keep it on Saturday.
No, my Lord.
We are keeping it on Monday.
Yes.
On the prayer of the petitioner, the matter is adjourned till.
Your lordship is to Tuesday, my lord. Monday is the mentioning day, my lord knows.
Adjourned till November 19, 2024.
Grateful to your lordship.
Thank you.
Lord, I appear for the appellant matter led by Mr. HON'BLE.
Yes.
The client has communicated to us that they don't want to proceed with the appeal. But although if my lord insists on a written instruction, we don't have that.
No, we don't insist on written instruction for us, for you, because
No,
later
Mr.
on
Roy
if
has telephone.
that will suffice. Because otherwise, what happened? I was at the bar a few days back, so we know that subsequently, if the client denies, then he will be in jeopardy. That's why.
Sure, ma'am.
Very well. We don't require any privileged communication to be kept on record. Learned counsel for the appellants submits that the appellants do not want to proceed further with the appeal. Full stop. Accordingly, FA 10 of 2023 and Can 1 of 2020 within bracket old number Can 1297 of 2020 are dismissed for non-prosecution without any orders to cost. Stop. Interim order, if any, stands automatically vacated.
I'm grateful.
Thank you.
Item 8.
অর্ডার হ্যাঁ ওটা লাগবে। None appears for the parties at the time of call, full stop. As a last chance to the petitioner to move the matter, the same is adjourned till November 18, 2024. 18 November, সোমবার।
Nine, my lord, I am appearing for the opposite party in
Opposite
connection. But yesterday also, my lord, none appeared, my lord.
Dismiss for report.
কালকেও তো appear করে। Order record হয়েছে, কালকে appear।
We are traveling between two extremes now, dismissing for default and hearing appeal hearings. This is the second occasion when none appears for the appellants, but the respondent is represented through counsel. Full stop. Accordingly, can 1 of 2023 is dismissed for default without any order as to cost.
Lord,
We cannot dismiss the
no,
appeal
Lord,
because
it is not ready for you.
not ready for.
I'm grateful.
Thank you.
Your Lordship, I'm for the appellant. Your Lordship, the lawyer representing the appellant is a bit sick, is taken cold and cough.
And an adjournment is sought on behalf of the appellant. Full stop. Accordingly, let the matter stand adjourned for the day. Please give your name.
Lord, this matter here, my juniors' names have been included. Madhumanti Das. They obtained the no objection from us. Well, kindly record his name there as because
His name will be recorded.
I am searching my the free in my chamber as because it was filed during the.
No, we are recording his name only. Yes, next.
Polumi Dotto, you know.
Yes. Yes, sir. What is the matter?
I'm appearing on behalf of the plaintiff appellant.
Plaintiff, what is the suit for?
Suit for partition and declaration.
This is appearing for the first time or you have served? Application?
Served, Your Lordship. Initially, the matters came up on.
They have appeared previously. No, they haven't appeared. Is your affidavit of service ready?
It is not ready, but I'll make it one.
Make it
But
ready.
we'll serve, yes, sir.
Come back on Monday, we'll take
Yes,
up. It has been served.
Yes.
Then we'll dispose
There's an
of.
order, Your Lordship, on 1st of October 2015.
Yes, yes. You have rectified, the defects have been rectified. Certified copy was sent down.
Report is there. It came back uncorrected. There's
Uncorrected?
Yes, Your Lordship. It was not corrected. And it came back again. There's a report of 26th of June 2023.
Achha, let us check up.
But neither the rectified certified copy of decree in partition suit nor any report has yet been received by the department from the learned counsel. In view of the above circumstances, a reminder was given to the learned trial court.
It is seen that despite several directions of the court, the certified copy of the decree in the partition suit has not been returned from the court of the learned civil judge senior division, Chanchol, Malda. Full stop, next para. The district judge, Malda is directed to file a report as to the cause of the delay in rectifying the certified copy of the decree as well as to the delay in sending back the papers to this court. Such report shall be filed on the next returnable date. The matter shall next be listed on December 12, 2024 under the same heading. This order be communicated by the department immediately to the learned district judge, Malda.
And I shall file the affidavit of service on the next date.
Yes, on the next day, because otherwise it's difficult. The appeal remains defective.
Obliged to lodge.
এইটা একটুখানি দেখে নেবেন, হ্যাঁ, যাতে কমিউনিকেট হয়ে যায় অর্ডারটা একটু ডিপার্টমেন্টকে জাস্ট বলে দেওয়া যে নেমে যায়, যেন তাড়াতাড়ি কমিউনিকেট করুন।
My lord, in item number 12, Mr. Shwani Chakraborty is appearing on behalf of the respondent.
Since one of our relatives within bracket Bhattacharya J bracket close is appearing for one of the parties in the matter, the matter is released from this list on personal ground with liberty to the parties to seek assignment before a different bench.
I'm grateful, Your Lordship.
Thank you.
Lordship, I appear for the husband, Your Lordship, petitioner.
Yes.
It's an application under 13(1)(b), Your Lordship, for divorce was filed. Suit for divorce was filed, Your Lordship. Now, Your Lordship, I have served on 3 occasions, Your Lordship.
Served the application?
Of the wife, Your Lordship.
Affidavit of service?
Affidavit of service is on record, and twice directions were given, Your Lordship, on by the order dated July 2, 2024, as well as
Yes.
Your Lordship, April 30, 2024, but I did not prepare for the second and the third services any affidavit of service because no such direction was given, but I have served.
Prepare the affidavit of service, come back on Monday, we'll dispose of the application. What is the application
It
for?
is simply, Your Lordship, they dismissed it on the ground that I did not file my affidavit in chief, and also I did not give my evidence, the husband. Although the daily orders, Your Lordship, records that I had filed my affidavit in chief.
You had?
Yes, I had. It is on record also. Just that dates were fixed day by day, 10th, 11th, 12th. So 11th was the date I could not. I had sought adjournment. They closed the evidence, but on the next day I submitted the.
You can dispose of the appeal.
You're directing that they may consider.
Yes, but for that you have to file a affidavit of service.
Yes.
This application is for what?
The application is just to bring on record, Your Lordship, all the documents so that
Can you prepare your affidavit of service during the course of the day?
Your Lordship,
difficult.
It would be preferred if it's on Monday. I can try in the course of the day, Your Lordship.
No, come back on Monday. It is pointed out by learned counsel for the appellant stroke petitioner that despite several services, the respondent wife is not appearing. Full stop. Next para. The learned advocate on record for the petitioner shall file affidavits of service to that effect on November 18, 2024, when the matter shall next be listed under the same heading.
Yes, sir.
Come back on that date, we'll consider.
This was for the court.
কি determination? This is one thing. আচ্ছা, আর এমনিতে তো কোনো মেনশনও হয়নি। আপনি মানতে যাবে কোথায় আছেন? তাই বলি হঠাৎ কোয়ালিটি অফ এত বেটার হয়ে গেল।
40.
Item number 14, Lordship, I appear for the appellants.
Right.
This is my application for condonation of delay, wherein there is a delay of 36 days.
Have you served on the other side?
We have not served.
Very well. Serve a copy and come back. How soon can you serve? We are on 14th today. Could you keep it on 28th?
There are 18.
18.
Yes.
We'll keep it in the monthly list of December. Come prepared.
Great.
How many appellants are there?
18.
Appellants.
Oh, appellants 3. Lordship.
The appellants shall serve copies of the application on the respondents, indicating that the matter shall be listed in the monthly list of December 2024 and file an affidavit of service on the next returnable date to that effect.
Grateful.
Serve them, come back, we'll allow the application and pass direction.
Great.
Okay. You are for the appellant?
My lord.
Other side is not appearing.
Lord, I have been directed to serve, my lord. I have served, my lord.
Service has been effected. Please check up. Effective.
But item delivered to address him, lord.
Please file the affidavit. What is the matter above?
Lord, I have been directed to deposit the Talovana, and that has also been deposited, my lord. The status report says so, my lord.
Well, what does the matter arise from?
The matter arises, my lord, out of a decree, my lord, thereby dismissing my, thereby decreeing a suit, my lord, whereby my deed of gift has been cancelled, my lord. The deed of gift has been executed in my favor, my lord, and the daughter challenges the deed after a period of, my lord, about the deed was executed in the year 2001, my lord. And that suit was filed.
But there is no scope for stay. Stay means the deed will be revived without hearing the appeal.
No, my lord, I have paid for the injunction, my lord.
Your application is for stay.
And my lord, if your lordship kindly looks at the alternative prayer, my lord.
Achha.
Because on the basis, if your lordship kindly looks at the decree, my lord.
Decree you have seen. Injunction that they cannot, you cannot disturb their possession also. Apart from
They are not in possession.
But the decree stands till we set aside. If we set aside. Because the decree says that you cannot disturb their possession. Let us come to the decree. The 4th paragraph of the decree says defendants are hereby restrained from interfering with the plaintiff's peaceful possession. So there's a finding, a decree against you. Unless the decree is set aside, we cannot direct.
On the other hand, they have filed another suit now, my lord,
we can
for recovery of possession.
We can do. They have filed a suit for recovery of possession.
Yes, my lord.
Have you annexed those things in your application?
Subsequently, my lord.
Anyway, regarding possession, we'll direct the parties to maintain status
My lord,
quo.
that will suffice.
And regarding transfer, we'll pass an injunction.
Fine.
Despite service, none appears for the respondent at the time of call. Full stop. Affidavit of service filed to be kept on record. Full stop. Since the appellant stroke petitioner has made out a prima facie case for hearing the appeal on merits, comma, the respondent is restrained from restrained by an order of injunction from transferring, alienating, and or encumbering the suit property in respect of third parties in any manner whatsoever till disposal of the appeal. Full stop. The parties shall also maintain status quo with regard to possession of the suit property, comma, also till disposal of the appeal. Full stop. Can 1 of 2023 is disposed of accordingly. Full stop. There will be no address to cost. Full stop. Next para. The appellant shall put in the requisites within a week from date. Full stop. The records be called for by special messenger at the cost of the appellant, also to be deposited within a week from date. full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the records on the learned advocate for the appellant. Full stop. Liberty to mention the appeal for inclusion in the list for hearing as and when the appeal is made ready for hearing.
I'm grateful.
ভালো এনকোয়ার করে দিচ্ছে হ্যাঁ ওটাকে স্টে করা মানে ডিগ্রি রিভাইভ হয়ে গেলে মুশকিলে
Yes, Mr. M.
এলসিআরটা আছে দাদা? একটা জিনিস জবসকে দেখিয়ে দেবো। But there is a question put forward in the cross-examination of PW1 that whether you are willing to ask for fingerprint expert or whether it is named as signature expert. Subsequently, after he refuses the same, my lord, an application was filed for holding from the LCR, my lord. This is the order rejecting my application. The grounds has also been taken in the memorandum of appeal.
In the memorandum of appeal, you have set up the irregularity of this order as a ground.
Yes.
Very well.
That your lordship find at ground number.
Now, what prevented you from referring to this on the previous occasion? Lack of preparation?
To some extent. I was candid, your lordship.
But we'll have to keep copies of these on record.
Yes. Ground number 5, 6, and 7. On this business suit, I'm not granting any opportunity to prove.
Which witness?
PW1, my lord, if your lordship.
Give us the page number.
Yes, my lord. DW. হ্যাঁ এই দেখ আমারটা এটা না রে না ইয়ে যেটা হয়েছিল যেটা বললাম আমি কোনো ইয়ে করবো না প্রসেস না যেটা ইয়ে করবো না বললো আমি কোনো হ্যান্ডরাইটিং এক্সপার্ট No, my lord.
Because LTI is the thing which has to be. We were rather surprised yesterday because that you had not.
Yes, I missed, my lord.
Because your only case was that you had not executed the document and the LTI is not. LTI examination was refused by the court.
Yes, that is the order I have handed over to your lordship, a certified copy of the order. That it was asked after the cross-examination of.
That is the best evidence available. I mean.
And objection.
Yes.
Objection given by the.
That we are not sure. Objection as a matter of course is a prevalent practice in our state.
But if you file objection, refuse to
file an application, you have to file even if you pray for something which is in their favor.
Because my lord, if you file an objection for the
handwriting expert would have to say these are their LTIs.
LTI.
That would clinch the case against you.
And if he opposes the same, my lord, it presupposes adverse inference ought to be have drawn.
We feel sorry for the other side.
কত ওইটা যশোর 100 কত বললি যে
আমরা করিনি ডিটেইলস
এক্সপার্ট মিনিটের ব্যাপার
Page 118, the cross of DW1.
You showed that to us, but we forgot the page number.
Yes, ma'am. Page 118. The cross-examination of DW1.
Yes. I shall not ask for.
After that, my lord, I filed this application indicating that in spite of asking that defendant number 1 refused to ask for any handwriting fingerprint expert.
Signature
Signature, my lord, that is, though it is verification signature, but LTI. And after that, my lord, your lordship find this application was filed indicating that at the time of exit cross-examination, the DW1 said that he will not ask for any examination. So, for the purpose of asserting the real controversy, this application was filed for.
Obviously, after this you have filed. Because,
yes, the
but
court
said it-
rejected that it is a delay.
Late.
Late. And one thing, my lord, may I draw your lordship attention so far, section 30. Even presupposes, my lord, it is a suit for declaration and injunction in that score also. Though injunction, even in lordship can be considered to that aspect, that injunction cannot be granted in view of without implementing the other persons as parties, whether my declaration is barred under the law. Akamma.
Akhamba.
Akamma. Yes.
It was very close to Akhamba.
There says, my lord.
Akhamba is what? It's a case law?
Yes, yes. There it says, well, the declaration can be granted in a state of fact that consequential relief has not been paid for. Be as it may,
they have not been. No. Regarding relief, it's different.
Yes.
All parties, that says all parties.
No. I am saying, my lord, this is a declaratory suit. It can be, it is binding upon the parties under section 35. So my cause of action against the person who is denying my title regarding for enjoyment of the property. Even if, my lord, this declaration, if granted under section 35, it will binding between the parties. It is a judgment of personal name. It is not a judgment on rem. So the other, even if the co-shares are there, it is not binding upon them also. So whether my suit
If share is declared, it is not binding. What does it
mean?
mean?
Share, I am not declaring.
The absurd proposition.
But can you consider it is the
you claim a share in my property. Suppose you claim 99% of the property. That's granted without impleading me.
I am not.
Just because I have not protested. And actually, maybe I have 99%. You get a declaration by setting up one of the other co-sharers and saying that only he objected, I implead him, and I am owner of 99%.
Only one thing, my lord, can you consider? Here is what is the cause of action filed, my lord? The deed, the document.
Cause of action is not the only determinant.
The
relief sought is also a determinant as to who are necessary parties. Cause of action does not necessarily determine the necessary parties. The relief sought determines the parties.
If the relief is one of the declaration that the deed which is
suppose you seek for an injunction restraining the defendant from disturbing your possession, then obviously others may not be necessary parties. But if you seek a share in the property, everybody who has a share in the property is a necessary party. Anyway, we will record
now the partition will leave
cite your Akhamba.
Akhamba. What's it? Akhamba. My lord, can turn to B. It don't be after that, my lord.
B.
This is head note B, my lord. And the relevant paragraph, my lord, I am drawing attention. That is on page paragraph 22 to 24.
What happened?
Nothing. Yes,
yes, the proposition is also very interesting.
I was stunned, and then I told that to the Basu. He said, I don't look into this judgment. I said, I can't lose both ways.
Thank God, my lord, in the year 2024, the previous position was restored, has been restored.
Regarding this?
Here said one of the consequences.
You also cite that judgment.
Yes, that's why I am submitting the law. Otherwise, I should not.
No, let us see the proposition. Yes, para 22.
Yes, sir.
Place it, Mr. Prai.
Yes, my lord. The prohibition or bar contained in proviso to section 34 of this specific act determines the maintainability of a suit and that the issue has to be tested on the basis of the plaint as framed. If the plaint contains claim for declaratory relief, as also consequential relief in the form of injunction that would insulate a suit from an attack on maintainability on the sole ground bar mandate in the proviso to the aforesaid section. If on evidence the plaintiff fails on consequential relief, the suit may be dismissed on merit for the plea so far as the plea for consequential relief is concerned, but not the maintainability question invoke the proviso to section 34 of 1963 Act. The plaintiff otherwise succeeds in getting the declaratory relief, such relief could be granted, which is contrary to subject to question of the section 34 of the Special Relief Act. And it was held.
Mr. Rai, there is something here that Section 34 proviso does not say all other consequential reliefs have to be sought.
Reliefs we can.
Possible proposition that yes, being able to seek, but whatever you are able to seek, you have. Here it was a case of kosher errors. In this case,
declaration and injunction. Declaration sought for here is much
declaration
more.
of title, exclusive title maybe.
Here the admittedly disposes, not seek is for recovery of position. In that suit, this honorable apex court has said in that way.
They paid for injunction.
They paid for injunction without recovery of position.
They admitted that they are not in position.
Yes. My lord. Paragraph 24. The trial court came to positive finding that the original plaintiff was the owner of the suit property, but it was held that in absence of declaration of relief of position by the plaintiff, declaring the title cannot be granted. My lord, got it? Paragraph 24.
No, probably they claimed position, but failed to prove it ultimately.
No, it is. Previously, that's a paragraph 24, my lord. Can you consider paragraph 24? The trial court came to a positive finding the original plaintiff was the owner of the property, but it held that in absence of declaration of relief of position by the plaintiff, declaration of title cannot be granted. We have already expressed our disagreement with the line of reasoning. It seems to be a misconstruction of the provision of 34 of the 1963 Act. The trial court and the High Court have proceeded on the basis of that expression further relief. Employed in the proviso must be included all the relief that ought to have been claimed or might have been granted. But in our view, that is not the requirement of the said proviso. This takes us into the corollary question as
So,
to
Mr. I come to paragraph 23, that will explain.
so for the release claimed in the suit, out of which this appeal arises, prayer for declaration was anchored on two instances for interference with the position of the land of the plaintiff and injunction relief for restraining them interference with the property was also claimed. But position of the said property by original plaintiff was not established. The alternative relief sought to be introduced at a later stage of the suit was also found to be incapable of being entertained for the reason of limitation. Thus, the foundation of the very case of the plaintiff based on these two factual grounds collapsed, with the fact-finding courts rejecting both the assertion or allegation. But
What happened here, they anchored the plaintiffs anchored their case on that their position was being disturbed by the defendant. And they paid for declaration and injunction. Ultimately, they failed to prove position. So, court held probably that at the inception, the suit is not maintainable. If being able to claim, they did not claim. If subsequently on fact finding it was found out they are not in position, then the suit is not, it's not that the suit is not maintainable at the inception. That may be a reasonable proposition. But yes, if they admitted that we are
yes,
not in
if you're logically on paragraph 21, because this is now, my lord, academic to that extent, because in view of the subsequent judgment, my lord, it was held that
position was not established.
No, it is a plain for the relief of injunction or asked for such a dual relief would protect the suit from being dismissed on maintainability ground. It is the fact that plaintiff ought to have asked for recovery of position given the factual background of this case. But the plaint, as it is originally framed, reflected that the original plaintiff was in possession of the suit land. Such plea rightly failed before the trial court and the first appellate court. Because, my lord, if you lordship previous to that, my lord, it was held that the plaintiff was not in possession. Be as it may, my lord.
No, not what you are making it out to be. Their plaintiff's case was that they are in position, that position is being disturbed, and they sought for declaration and injunction. Ultimately, their position case failed, and the Supreme Court held that no, declaratory relief is maintainable on the face of the plaint. As per the averments in the plaint, we have to go by that. They sought for injunction rightly, but they failed to prove their position, so ultimately it cannot be granted. Maybe they should have amended the plaint, and what that has been held here. Court is correct. This proposition is correct, Mr.
Well, subject to question, can turn to paragraph 4 of this judgment.
Yes.
The subject suit, 1987 suit was founded inter alia on the allegation that the defendants are making attempts to interfere with the original plaintiff's peaceful position. My lord got it.
Exactly.
An enjoyment of
That
the
clinches
property.
the issue. They were making their case
It
was
was
that defendant-
allegedly, specifically alleged that on such and such the defendant interfered with the peaceful position and enjoyment of the suit led. It is also been alleged the plain attempt to trespass in the suit property was repeated.
Para 4 makes it very clear.
This is the what is
Their
fundamental.
case was their possession, their enjoyment of the property, defendant are interfering, trying to trespass.
After that manner, the original plaintiff has issued the earlier suit. In the 1982 suit was perpetual injunction, and the claim for injunctive relief was similar to that asked for in the 1987 suit, though not a same allegation of interference. The earlier suit registered such as the said suit dismissed by the trial court on the ground that plaintiff could not establish his lawful position. The previous suit, it was held that you are not in position. Subsequently, suit was filed on the allegation.
You are citing this for what proposition? In your case?
That even if my lord
that partition
that the partition
need not have been paid for.
Partition are paid for, even if it's for non-general necessary, partition cannot be granted. Then my declaration so far the deed is concerned and my right.
Partition you have asked for.
Asked for. But non-general necessary, but if you logically consider non-general necessary parties, whether my declaration portion regarding the deed and other things can be also be said to be non. The prayer is not maintainable in otherwise.
That proposition.
Here also said that.
No, you may say one thing. You may say that the declaration was regarding not only your title but
the deed document. So that document
deed for declaration regarding a deed, you are right, Mr. Rai, because the deed only the parties to the deed have to be defendants.
So my position on injunction can be different. So declaration can be granted in view of this judgment. Non-general necessary parties and other things, my lord, I could have understood there is a recurring cause of action for partition. I can ask for the partition on the basis of this declaration. Because the document which I have challenged is an interest between the parties.
But Mr. Rai, then very well, let us accept your proposition that the declaratory relief is not barred by section 34 provision. But then, once you get the declaration, you have to get a consequential relief. How can you get partition without impleting all the co-sharers?
Yes, for that one, I have to ask for the partition or joint partition. If
I have asked for partition.
If the partition cannot be granted in view of the non-general necessary parties, whether this can be a ground, it is a recurring cause of action. Consider it is a recurring cause of action.
You can always amend.
I can amend and ask for the subsequent partition also.
This judgment.
That's for that reason, my lord, I am drawing lord's attention. My lord, can consider a joint position. As position I can ask for also without seeking for partition.
All right. Very well. Very well.
Yes, no. And the carpet case. And if your lordship can consider the nature of the cross-examination of the plaintiff, defendant to the plaintiff, your lordship find no questions put forward that he is not present. You are present on that date. You put your signature. It was read over and explained to you in a manner. Nothing has been put to the cross-examination of the PW1. That your lordship will find from the cross-examination. I want to, for the sake of repetition, my lord, I draw your lordship attention. PW1 cross 91, 92. My lord, can you turn to 92 onwards?
This is your cross-examination?
Yes, PW1. Now, can you consider 93?
Yes. What?
There is nothing
regarding
the presence, execution, the document. If your lordship may kindly consider, I have said that I did not execute the document by false prosecution. It was executed. In my chief, I have stated categorically. Now, my lord, kindly consider
in your chief, you have stated you are not present.
Yes.
Shows that?
Yes, my lord. Paragraph 6-7.
Page
88. In my chief. and also the limitation, because my knowledge I have
You have not stated that you are not present in specific terms. You
I
said-
did not execute. That means the LS document which you have, that I am not there. And also the date of the knowledge. Because the learned court below also dismissed my suit on another ground is limitation, my knowledge. My lord, my specific case is that I came to know about the fact of this deed on 2013. That your lordship find paragraph 6, last 3 lines. But the plaintiff never executed a registered sale deed or any other deed in favor of defendant number 1, and the cause of action arises from the date of knowledge on 28th February 2013 within the jurisdiction of this court. So this is a specific assertion. Now, my lord, can you consider what are the questions put forward in cross-examination to counter my affidavit? So far my knowledge, no question put forward.
All right.
So in view of the Canapet case, my lord, if a lordship material question was not put forward, whether it can be termed to be an admission. That is reported in 19...
You cite Carapet also formally. No, cite it for the sake of completion.
Yes. কই আর জাজমেন্টগুলো কই জেরক্সটা এই যে এখানে আছে নাকি না 1961 ক্যালকাটা 359 তুই বলেছিস বার করেছিলি
What is the paragraph?
Yes.
Carapet? Any particular paragraph you want to?
Paragraph 9. My lord, may I read out for your lordship 8 and 9. Failure to put the important crucial part of the case to the witness coming.
Sir, please have it Xerox in the
Yes, yes, just now I'll get it. Just I'll hand over a copy.
Well.
2 copies. 8 and 9. Failure to put the important and crucial part of the case to the witness coming to prove.
Did not read it out. Just.
My lord knows better than us about the.
Take out photocopies and
Just made it. 2 copies. So now, my lord, I want to sum up my argument on this court. My lord, the case made out by the plaintiff is that from a particular date I came to know about the facts of those deed. I never executed the same, and the defendant is trying or disturbing my age-value position. On the basis of the case, my lord, the defendant being the beneficiary of the said document, my lord, categorically said it was properly executed. From the evidence I am satisfied, it will appear there is a not only contradictory or mutually destructive pleadings so about the evidence and the written statement.
So, Mr. Rai, if you may sum it up, correct us if you are wrong, add whatever part. One is that there is discrepancy regarding the date of examination, execution and registration between pleading and their evidence. 1. Secondly, plaintiff number 2 was a minor at that point of time, which is evident from page 125 and 128. PW2 admitted 18 at the time of execution, younger sister.
Younger sister.
Third is that all the 3 executants of the deed were illiterate and put LTIs. No statement, nothing, no proof of read over and explained.
Only 7 except in the deed itself, my lord, at the bottom your lordship find. That's why on the earlier question I have shown to your lordship that it was mentioned that
this is page?
Page, my lord, the volume 168, page 168.
What is there at the bottom?
দলিলখানা পাঠ করিয়া দাতাদের অবগত করা হইল at the bottom, my lord, you'll find it is my duty also pointed out to lordship. But who, my lord, the সুরেন্দ্রনাথ সরকার.
Who was Surendranath Sarkar?
According to the দলিল লেখক, the scribe.
He was not an evidence,
No.
not a witness here.
No witness. Apart from that, the person who was the attesting witness and identified the LTI, that Gopal Mundal and Vibhuti, according to the DW2, my lord, they denies the presence of those 2 persons. If your lordship.
Yes, DW2 says doesn't
I know whether or not Gopal and Vibhuti were present during the execution of the sale deed by plaintiffs.
Page 127.
Yes, my lord. No,
Yes. Another is non-joinder on which you cited this judgment also. And the next one is
adverse
no
information.
statement in your cross whether you are present or not.
And also the date of the knowledge, my lord. Kindly consider
Date of?
date of the knowledge of the, because my specific
Limitation
case,
also.
limitation.
Limitation. Limitation is because limitation is also one of the ground.
One of the ground for dismissal of my suit.
So limitation, non-joinder. Non-joinder is your worst point. Probably.
That is the worst point.
I mean, because you also claim partition, that's why. We'll consider that.
And so far, filing objection to my application for appointment of fingerprint expert, my lord, the court ought to draw adverse inference against the person who filed the objection and
yes.
114 of the
order
evidence.
and application. Very well. Nobody appeared for the respondent all along. But
Initial, as is a Vishwajit theory was there, man, for the respondent number 1.
Yes. What happened to him after that?
Or after that,
You got afraid after knowing that you were also appearing.
That much ability I don't have.
Anyway, very well. We'll conclude hearing. Heard learned counsel for the appellants, pushed up. Although the appeal was heard over several days, on none of the occasions the respondents were represented through counsel, although the respondent number 1 had been initially represented through counsel in the appeal. Full stop. Accordingly, the arguments are closed. Full stop. The matter is reserved for judgment.
I'll get it photocopy of that judgment
Photocopy of
and I'll hand over to your lordship.
এটা একটুখানি স্টেপল করে এই কোথাও একটা এই পেপার বুকের এখানে দিয়ে দিন। Judgment. The appeal itself is ready for hearings. Yes. It is 17. দেখুন লিস্টে পার্ট 1 এলসিআর কিছু লেখা নেই কি দিচ্ছেন
ওই মেমোটা কারেকশন করে
রিফ্লেকশন ভালো হচ্ছে
ও আচ্ছা কিছু লেখা সেটা আমাকে দেবেন সাপ্লিমেন্ট ঠিক আছে
যদি না থাকে ঠিক আছে
After substitution, your lordship directed that a fresh memorandum.
Yes. This just formality. So why 2? You have got copies of
that is not regarding the amended blood cost title blood I don't need if that be
but why 2 copies I mean
Given
extra copies
তাহলে আমাকে দিয়ে দিন
2 for each of the judges you take the paperback and we will take the hard copy the hard cover yes
ঠিক আছে
yes Mr. Rai please
Defendant is the appellant before your lordship in a suit for partition. Well, it is against the final degree.
Preliminary degree was not challenged. Very limited scope.
Yes. Now let may I take before your lordship the plain first, some paragraph.
Yes.
in the plaint,
Hmm.
the plaintiff described how the properties has been devolved upon the parties. In so many paragraphs from the.
But Mr. Rai, the scope, the share has been declared. You have no qualms with that because you have not challenged. Now, only we are concerned with the probably the Partition Commissioner's report.
What I want to show that in the plaint, the how the property is devolved upon the parties, all the plaintiffs and the defendants, that has been described. Now let's kindly come to the schedule of the plaint at page 11. Several properties were there, but kindly see the schedule of the property. Schedule in respect of only two plots.
Oh.
345 and 346.
Yes.
Why I am showing this to your lordship, that it was also my contention in the trial, on the preliminary degree was passed, that all the properties were not brought into the hotspot of this schedule of the. Now kindly come to
the plaint states about other properties.
Yes, that's the plaint states about other.
That's why you are showing us.
Yes.
The plaint states about other properties also, but those were not included.
Those are not included.
Very well.
Because some of the properties are.
But why didn't you prefer a challenging in the preliminary degree then?
At that point of time, I was not there. Now kindly come to the preliminary degree. In the written statement, I have taken this point and I have also stated that some of the properties were sold by the plaintiff. In the plaint, it was the contention that although the properties were occupied by the parties, but there was no formal partition between the parties. So
Mr. Rai, we have to confine ourselves to only this because we cannot reopen the preliminary degree.
That's normal. Kindly see that I
obviously you know better than us.
Now kindly come to the preliminary degree. Kindly come to another judgment at page 81. Now we argued that there was oral partition between the parties and that was given effect to. The court says there is oral partition, but properties are not recorded in the name
Separately.
Separately. Now, in one hand, the learned judge accepted that there was oral partition, and on the basis of the oral partition, some of the plaintiffs sold the properties. But on the other hand, it says that although there is oral partition, but since the properties are not individually recorded, so the preliminary degree was passed declaring the share. That too only in respect of these two plots, because the two plots has been mentioned in the schedule, other plots were not mentioned. But when the preliminary degree was passed, all the properties were partitioned. It has been mentioned that in respect of the all the properties, but only the schedule was in respect of the two plots, 345 and 340.
But in the plaint, the prayer must have been confined to the schedule.
Yes.
But no, preliminary degree, page 10 says a preliminary degree for partition of the properties in suit according to the share of the parties. Properties in suit is schedule.
Schedule.
So we cannot improve that.
That is in schedule.
But then you are inviting us to go the final degree court to go beyond the preliminary degree.
How far I can argue before your lordship with regard to that?
You've already finished your argument.
Since the
we are feeling eager to challenge the preliminary degree, but we cannot touch it even. Even the Supreme Court cannot touch it since you have not challenged.
I am very much conscious about that.
Whichever way we are thinking, I was thinking whether there is any scope. No scope.
But since the initiation of the proceedings is the plaint, Now, since the initiation of the proceeding is bad, all steps taken after on the basis of the initiation of the proceedings are bad. That I want to submit before your lordship. Because the
Initiation bad because of inclusion of all properties.
Mentioning the other properties into the not bringing the other properties into the hotspot. Now, kindly see the preliminary degree. And after discussing the everything, the preliminary degree is held at page 91.
Yes.
That the may I read?
Is the ordering portion you're reading?
Ordering
Yes. We are at the decree itself, 95. Same, all the same.
The parties to the suit shall hereby directed to get the property decreed on contest against defendant number 1 and ex party against the rest of the defendant to get a decree for partition in preliminary form. But the share has not been specifically mentioned in this decree. Share has not been mentioned. Now, finally, come to the decree portion also. In the decree,
The decree, we are looking at the decree page 95, same.
95.
Nothing.
Share has not been declared. Unfortunately, my client has not challenged this decree.
Cost should be imposed on your client for not challenging the
Not
preliminary.
challenging. Yes, that's true.
So you may say, how can a final degree be passed at all? Yes, yes.
Not only perhaps not something is that is being challenged by the defendant number 1 by filing a first appeal.
Oh,
the other entire finding is being affirmed apart from the fact
that first appeal
since-
is pending.
Since this was not, the share has not been declared, apart from the every finding of the trial court is not being touched in that first appeal, only a direction for the limited direction for the purpose of only detailed calculation of the share. Thereafter, a subsequent preliminary decree, not only on direction of this honorable court, only the shares have been declared.
Why didn't you ask for a supplementary paper book? Those
I have not today for the first time, after the application is being moved, I have prepared that. That is not included.
Mr. Rai does not have any idea of that.
No, perhaps it's their application before this in this connection.
We said Mr. Rai has no idea of
it. In connection with this appeal, the other application.
I should not have mentioned before your lordship this.
No, that's why, the other application filed by the appellant in connection with this appeal contains these papers. That is already disclosed. Kindly
give a copy to them also, so that there will be uniformity. Oh, this is the copy of
that first appeal, my lord.
After that, what happened?
After that, the supplementary preliminary decree, as per the direction of the first appeal, is at page 17 of my lord, that compilation I have handed over.
Achha.
And the deposition, the cross-examination of the partition commissioner, that is also not included. That's why I have incorporated that also in my compilation.
Sir, we think you should look into this and come back. Yes. This will create an effect.
Yes, yes.
At order record, when the hearing is commenced, it is pointed out by learned counsel for the respondent. Number 1, Mr. Mukherjee, you are appearing for which respondent?
All plenty.
Appearing for the respondents, submits that the preliminary decree had been challenged in a first appeal before this court, which had been decreed, remanding the matter to the court below in a limited context for declaration of the shares, respective shares of the parties. It is submitted that thereafter a decree was passed, a preliminary decree was passed afresh by the trial court in the light of such observations of the appellate court. The copy of the said judgment of remand and the preliminary degree passed thereafter, as well as cross-examination of the pleader commissioner in connection with the final degree proceedings are handed over as a compilation to the court. Full stop. A copy thereof is served on the learned advocate appearing for the appellant as well. Full stop. Next para, in order to enable learned counsel for the appellant to consider the same and address his arguments thereon as well, comma, the matter is adjourned till, we'll keep it on Tuesday, we'll get a long weekend. The matter is adjourned till November 19, 2024, when it will be listed under the same heading. Great. এটা তো ওই একই গল্প, হ্যাঁ, ছোটটা এটা করে দিলে আপনার ইয়ে হবে। বললাম না, রোজ একরকম
Email address here for the plaintiff respondents.
Responding.
Mr. Banerjee is appearing for the
You are for the appellant. Come.
applicant. না, না, আমি
Yes.
এই কোথায় অ্যাপ্লিকেন্ট কোথায় এটা তো ইয়ে অ্যাপিল হিয়ারিং এর জন্য
My lords will take up the appeal today, my lord. There's an interlocutory application pending, I thought.
Have you seen the order dated 4th of November?
No, I haven't actually. I think I missed
The court is apprised that the appeal is otherwise ready for hearing. Accordingly, can 2 will be listed along with hearing of the appeal.
Oh, I'm so sorry. Then please give me this long weekend. I'll come back on 19th, finish it up.
Question of that. You are so easily, you are,
No,
that the direction was given on the last occasion. So convenient, Mr.
no, my lord, I was, এখানে কি ছিল? আমাদের কেউ ছিল?
হ্যাঁ ছিল তোমার
It's like asking who filed the suit.
No,
That's
it's not
the
like
process.
it's not like that. Not, I really thought.
Plaintiff filed the suit.
No, no.
You should have known.
Yes.
Should have come prepared with the appeal.
I should have, my lord. But I was under the impression
Start the appeal. You are a good debater. Start the appeal. Without preparation, you can start.
that I can, but I'll be wasting your lordship's time, my lord. Kindly take it up as the first matter on Monday.
Let it Tuesday.
Monday.
Monday.
An adjournment is sought on behalf of the appellant. Full stop. Let the matter stand over till November 18, 2024.
Obliged, your lordship.
It will appear under the heading application or hearing.
Hearing. Same hearing. Hearing.
Obliged, your lordship.
এলো না
Yes.
I beg to appear on behalf of the appellant of favor.
Right.
But Mr. Kormakar had said he'd take 15 minutes. I hope to, my lord, adhere to that.
Acha. Mr. Rice for the other side.
Yes.
He will take, my lord, 2 minutes.
Five.
My lord, plaintiff's appeal in a suit for eviction
These appeals are unnecessarily pending for so long.
never touched.
Never.
Never touched, my lord, for 3 years.
Out of that, you must have taken time for on 4 or 5.
Never.
There is no scope, my lord.
See, it was never called on. Forget about taking time.
Anyway,
My lord, plaintiff's appeal in a suit for eviction on the ground of 2G. My lord, out of 6 issues framed, all issues are, my lord, in the favor of the landlord, my client. The court, my lord, dismisses my suit on the ground that I haven't been able to show ownership with respect to, my lord, 632 square feet. The court says that I have shown ownership with respect to 400 square feet. And if a degree is passed, that would be splitting up of the tenancy. Because admittedly, the respondent tenant is in possession of, my lord,
enter
600 square feet. Now, what the court overlooked was that I am in possession, rather, I am the owner of more than 600 square feet, about 800 square feet. Completely overlooked that. That's the only point before your lordship. Because
No, no.
all other points.
How did it come to that conclusion? I mean, on the basis of a deed.
Overlooked. On the basis of a deed, but overlooked Schedule C. The
Of the
learned judge looked at Schedule B and one of their defenses, and my lord came to a finding that I am owner of only 432 square feet.
Have you annexed the deed? Let us start with the schedule.
Kindly looks to the finding first, then I'll take your lord.
Very well.
Looks to 42. My lord, I'll just very quickly, my lord, I'll my lord, show your lordship, my lord, the judgment and the issues there. Kindly first turns to 36, looks to the issues once. 1, 2, my lord, are formalities.
Yes.
3 is 2G. 4 is notice. 5, my lord, is whether he has a right to occupy. 6 is am I entitled to a degree of harsh possession, and damages and so on and so forth. My lord, if your lordship turns over, kindly first looks at page 37.
37 years.
At the last paragraph. Exhibit 1, my lord's kindly got that. Exhibit 1 and Exhibit A is admittedly deed of conveyance, which is I'm going to, my lord, rely upon. Dated 14th March 2007, by which the plaintiff claims to have purchased 2 separate shop rooms. Kindly marks that. On the ground floor of premises number such and such, the plaintiff in the cross-examination recorded on 26th of July 2022 and 22nd of August 2022 has admitted that the plaintiff has purchased 1 self-contained shop room referred to in Schedule B in page 11 of the deed, another shop room. Kindly marks that. This is where the learned judge, with a lot of respect, overlooked. In page 12 of the deed and the Schedule C is the correct description of the suit property. And my lord, your lordship will find now, shop described in Schedule C measures 432 square feet. Lordship got that, my lord? This is the crux of the dispute. Kindly turns over, my lord, your lordship will find at page 40, my lord will find, my lord, that the issue is in my favor. Issue wise, page 41, 2 and 4, my lord, is taken up. Your lordship will find 1 and 2 are decided in favor of the plaintiff at 41. Turns over issues 3 and 5, which were the most important issues, my lord. Issue number 3 and 5 are also decided in favor of the plaintiff. So the only issues, that is 6, 7 and 8, which is with respect to that 609 square feet.
Yes.
This is what that one paragraph is what the entire appeal is about. Though this court have decided the issues number 1 to 5 in favor of the plaintiff, yet this court cannot pass a degree for recovery of khas possession in favor of the plaintiff due to the fact that it is an admitted fact that the defendants are in possession of 609.32 square feet. And the plaintiff, by dint of deed of conveyance of Exhibit A, purchased 432 square feet. This is where, my lord, the anomaly lies. My lord, kindly straight away goes to that deed. Part 2. Kindly takes up, my lord, part 2.
Schedules begin at page 56.
Yes, my lord. No, my lord, in part 2, my lord.
Part 2,
Your lordship
page
will find
56.
something initially, my lord. Your lordship will find at page 10.
Oh, acha.
At 10. That is exhibit 1.
All right.
Lord, kindly first looks into this is my deed of conveyance, my lord, need not trouble my lord self. My lord, kindly have a look at the 800 square feet. No.
Why divided into so many schedules?
Lord, because these are two separate shop rooms which I had purchased, and the entire premises is one schedule, and those two
Two
schedules
shop
which-
rooms, common
Yes.
areas, another schedule like
Yes,
that.
something.
All right.
Kindly have a look at page 7.
Hmm.
Lord, quickly, if your lordship sees,
Mhm.
right at the top, your lordship will find that I have purchased about 864 square feet built up area, and which are there in schedules B and C.
Hmm.
Lordship got that plot?
Yes.
Turns over below to page 10.
Hmm.
B is 432 square feet. That was the
Yes.
learned judge's finding. And kindly turns over to C, my lord will find another 432 square feet. This is what the matter is all about. So it's basically a.
So we have heard you. Let us hear, Mr.
That's about
Any-
it. My lord, I am not even troubling your lordship with that because he has never questioned the identity of the property at all.
No, identity of the property?
Not questioned. My lord, his written statement was on 2G. And one, my lord, averment, which I must show your lordship in the written statement, which he says about, my lord, that 432 square feet, that your lordship will find, my lord, at page, written statement, it starts from 13, but the only part, my lord, which he really talks about this.
Does it talk about this?
No. I'm
Does it
sorry,
talk
I found out somewhere. Page 20. Say, I'm sorry, my lord. Yes, it's my mistake. Kindly see that, my lord, 29 in the examination in chief.
Yes.
Where he had said, my lord, that in paragraph 15.
But
where
this is
he had-
beyond the pleadings.
That's not just beyond the pleadings, my lord. Even if your lordship takes it within the pleadings, my schedule C, my lord, is pretty clear on that. So this was the only error, my lord. They have not challenged the findings at all by any means whatsoever with respect to the issues on merits. So I don't even want to trouble your lordship with that.
This is the chief of the defendant.
Yes, my lord.
Good.
So that's the only point, my lord, for your lordship's complaint. Identity, there is no dispute. Why do you want to waste time?
Take your 2 minutes.
As well as suggested by Mr. Chatterjee.
As Mr. Chatterjee. Mr. Chatterjee, there's a hierarchy in all civil code that has been said by, but what he has missed out is himself. Mr. Parthapatim Rai, Mr. Aniruddha Chatterjee, all of you come later.
Yes.
I am
grateful, my lord.
They are
I'm-
senior
I'm-
to you.
I'm
Mr. Bhattacharya, you, all of you come later.
Parthapatim
They
Rai,
have
I
to have
agree.
precedence.
Parthapatim Rai, I completely agree. My lord, your lordship knows from time immemorial. When he's joined the profession, my lord, he had, my lord, hierarchy.
But he once told me that judges are trying to stop my practice by propagating this in court. But that legacy is being perpetuated by us, this generation of judges. So he's in a difficulty.
My lord, Justice Kumar wouldn't know, my lord, whenever Mr. Rai used to appear before Justice Shubhra Kamal Mukherjee, my lord, his lordship would do like this. So we have something called a Madhuli. My lord, whenever a
Madhuli.
The moment he would appear, my lord, in court, he would do like this. Whatever he wanted, my lord, he had to be given. আমাকে
Contra view also on that.
That was a perception.
That's why we put him on the list also. We have put him on the list also. Anyway, Mr. Rai, what do you have to say?
Yes. Now, scope is very limited as Mr. Chatterjee rightly said scope is, and I also know. Now, kindly come to page 7 of paragraph 2 of the plaint.
You have a 5-minute breathing space. We'll come
Yes,
back in.
yes. And I was placing paragraph 2 of the plaint at page 7.
Page 7.
Yes.
May I read? The defendant was a tenant under the plaintiff in respect of one go down on the ground floor at premises number such and such under the plaintiff above named at a monthly rental of ₹75 only payable according to English calendar month, which is more fully described in the schedule hereunder written hereunder referred to as the suit premises. Here, the how much is the area that has not been mentioned, and it is described that this property is mentioned in schedule. Now, kindly come to the schedule as mentioned in the plaint.
Yes.
I will also calculate.
Page 10. Yes.
Yes. All that one go down on the ground floor at premises number such, and the same is butted and bounded in the manner following, that is to say, on the north by shop of Pranab Kumar De. On the south by partly covered and partly narrow space of the plaintiff, beyond which the shop of Devashish and Devobroto.
Right.
On the east by APC Road. On the west by the back portion of premises number 127A by 1 APC Road, garage space. And this is the description of the schedule, and the property is butted and bounded by these four corner. Now, kindly come to schedule C of the deed of purchase.
Yes.
There are 3 schedules A, B, and C. Right? Now, since Mr. Chatterjee says the B and C are the jointly property, now kindly, as I have shown to your lordship the schedule of the plaint. Now, kindly come to page 10 first of the part 2.
Yes.
Schedule B. Schedule B, it is butted and bounded by on the north by shop room of Shital Prasad, tenant. On the south, shop room of Hiralal Shah, that is my property, my tenanted portion. On the east by Acharya Prabhulas Chandra Road, 4 feet wide, vacant land within the premises. On the west by garage space of premises number such and such. Now, if you lordship kindly see, compare it with the schedule of the plaint, it will appear this is a separate property altogether.
This is so.
It is not matching with the schedule of the plaint. Now, kindly come to schedule.
This is a part of the probably the entire ownership.
Yes. Now, kindly come to schedule C.
C. Yes.
Next page.
Next page. Yes.
All that one self-contained shop on the ground floor of premises number 127A Acharya Prafulla Chandra Road, Kolkata 6, now known as 127A by 1 Acharya Prafulla Chandra Road, under PS Bortala, ward number 16, Kolkata 6, having road facing northern side, measuring about 432 square feet, built up area and extra 20% super built up charges described in the schedule C here too, together with all common facilities and amenities provided for shop, butted and bounded as follows. Now, kindly, this is important. Kindly compare this schedule with the schedule of the plaint. Side by side. On the north,
we have the two together. Yes.
Yes. On the north, by shop room of Pranab Kumar De at premises number such and such, that's tallied with the schedule of the plaint.
Only the surnames of Devobroto and Devashish are not given. Otherwise, it's same.
Yes, Devashish Karok, Devabrata, here it is not mentioned, surname has not been
Only
mentioned.
that
but
is the difference. Otherwise, it's same.
Otherwise it is same.
Yes.
So, the suit
And
property.
APC, it's written APC instead of Acharya Prafulacharya.
Yes, yes.
This is the only difference.
Yes. Now, my submission before your lordships, the schedule C is 432 square feet.
Yes.
Which is the tenanted portion.
Right.
My tenanted portion.
Yes.
Now, kindly now kindly come to page 20, the notice of eviction.
Yes.
Now, first paragraph, that you are well aware that on completion of construction of the new building of the said premises, being premises number such and such, construction of which was completed, and you have been provided with a tenancy in respect of a room on the ground floor measuring an area of 609.32 square feet with an open frontage of 10 feet with an inside height of 11 feet. Be it noted that prior to construction of the above, you were a tenant under Kumar Mitra and other at a monthly rent of 75. I am not going any further. Malad, I want to show that the notice was in respect of 609.32 square feet. And the schedule C, which was let out to me, it was 432 square feet.
But here in the notice, the tenancy is described to be of area 609.
609.
Tenancy itself is described here as 609.
Yes, 609. But Malad, he was, as in the plaint it is mentioned, the schedule, which tallies with Malad, schedule C of the purchase deed.
Yes.
And that is Malad with regard to 432 square feet. That I want to Malad.
But he did not challenge the notice, the identity of the property, nothing.
Identity property
identity of the tenanted portion you did not challenge, plus you did not challenge the notice. Even if you had challenged the notice, it is well settled, Mr. Rai, that if both parties understand the purport, then notice cannot be, fault finding approach cannot be there. For the
Malad, we agreed that our tenancy is in respect of 609 because Malad, it was alleged that the property was not in respect of 609 square feet, and that has been kindly come.
You are right in the notice that is there, but in the plaint they have categorically described your property to be that go down, which is of 432 as per the deed. They exhibited the deed. In the schedule of the plaint, they have given the description of the property, as you rightly pointed out. The schedule of the plaint exactly tallies with C, which shows C shows that it's 490 something.
432.
432, sorry. 432. Therefore, the plaint asserts that it's 432. In your written statement, you did not deny the identity. What you did not deny, you did not challenge the veracity of the notice. So even if there was a misdescription in the notice,
I have always
you have admitted the plaint case, not the notice.
I have always asserted that my tenancy in respect of 609.32 square feet.
In your pleading, that is not there.
Now, it was kindly come to page 67. Part 2, part 2.
We can look at the pleadings only. Written statement.
This order of this honorable court, wherein it was decided that I am in.
It was quoted by the learned trial judge along with the name of the judge also.
Yes. That it is in respect of 609.32 square feet, and I was permitted to cover this space.
This stray finding by a revisional court, Mr. Rai?
This was not challenged in before the higher forum. This is not binding.
This is not binding at the final hearing of the suit even, because cylinder revision is a cylinder. From that impugned order, whatever was the impugned, what was the impugned order? Repair, probably something like repair, complete work of construction of wall. So it can only be confined to that. It is binding only at that stage. But this finding is not binding at the final hearing stage.
But it is admitted that I am a tenant in respect of 609 square feet because notice was given in respect of 609 square feet.
That was a misdescription in the notice. But the
No,
suit
not notice of eviction. Kindly
notice
see.
of eviction describes it as 60 something.
Yes,
But the
609.
plaint assertion is that it's something else 432. That's supported by the plaint.
Plaint, nothing has been mentioned in the plaint.
You pointed out, Mr. Rai, that the plaint mentions C and C mentions 432.
432.
And they exhibited that document.
Yes.
So C and that C are identical. The plaint schedule and that C are identical, which says 432.
432. But the notice was given in respect of 609, which I am actually occupying.
He did not take that point in your written statement. In
No,
your evidence you have taken. You have not challenged the identity in the written statement.
In the evidence of the
Evidence you have stated that was shown.
on the plaintiff.
Acha. Let us see that.
At page 24.
Cross-examination.
Cross-examination, last 5 lines from bottom. It is a fact that the suit property is a portion of the property in the ground floor, beside which there is a 4-storied building. At this stage, witness was handed over the certified copy of the sale deed, and page 12, Schedule C was shown to the witness. After going through the Schedule C, witness marked Exhibit 1, yes, this is the correct description of the property which I have purchased.
The little case you had is demolished.
Because 432, that is with regard to the
432. They have asserted 432 in plain in their evidence.
Yes. Now, actually I am in 609 square feet in possession, and notice was given in respect of 609.
When the suit was filed in the plaint, it was specifically asserted that this is the schedule of the property which tallies exactly with their sale deed, which describes it at 400 something. In their evidence, plaintiff asserted 400 something.
Yes.
In your pleading in the written statement, you never disputed the identity of the plaint description.
But it is admitted. It is admitted that it is admitted by the plaintiff. That
the description in the notice, eviction notice, is succeeded by the filing of the suit by the plaintiff, where they describe the property according to their, and we have to look at the pleadings only. If there is a conflict between the description in the notice and the plaint assertion, then Mr. Rai, the plaint is subsequent. And that is what, because the court below has also held that they had succeeded on all the issues, which includes being entitled to an eviction on this suit schedule.
Kindly come to page 29 of evidence of the witness, defendant's witness.
Yes. Para 15.
Para 14 and 15.
14 and 15. Yes, 14 also. Right.
With regard to this, the statement that has been made in para 14 and 15, according to me, subject to your lordship kind correction, there is no state jacket, no suggestion, no cross-examination.
But can we look at evidence beyond the pleadings? If you say yes, we will accept that.
Well, there is a part there in the cross-examination. Witness, after perusing his affidavit in chief till the end, deposed that the contentions as is found in the said paragraphs of affidavit in chief is not found in the written statement.
That question was put.
That was put. And I should not be putting in more than what it is.
The question was put to Mr. Rai. Let us see. Fact that it is a fact that other than tenancy, that
No
I am
other
entering, there is no other than that. At this stage, witness was handed over. Perfect cross-examination, Mr. Rai. Perfect cross-examination. Only shown that there is variance between pleading and proof. Not a single question further.
Although it is but the learned judge has considered the scope of Order 6, Rule 2, as your lordship just now asked me whether in absence of the pleadings whether any evidence can be laid or not.
Considered.
But since yes,
What was the
at
finding?
page 38, since the parties were aware about the this tenancy, that page 38, last paragraph.
No, it's not actually a question of issue being not covered by implication. Yes. Forgotten what is there in this. Only arbitration act is in there. Where do I find variance between pleading and proof?
Yes, yes.
Smaller CPC would help actually. You have a CPC? You have a smaller CPC.
প্রুফেরটাতে এখানে এখানে এভিডেন্স দিতে হবে সেটা ভেরিয়েন্সটা তো এখানে আসবে
No, not there.
Right. On the contrary, my lord, it says that evidence need not be pleaded.
Yes, that is there. But
And that will come
Order
my lord,
6
from
Rule 2 is not
doesn't
German here.
Not German.
That is different.
That is with regard to what has to be
stated in the
exact
in the pleading.
pleadings.
That's all.
My argument is the parties were aware about the point that the tenancy not in respect of the 432 square feet, but in respect of, as I have added, arch 609 square feet, evidence was also laid by the respective parties with regard to the.
But even then, they are owners of more than that property.
That is with regard to the B schedule property is not at all to be
But
considered my.
if you cannot focus, it's like quantum theory. Either it has to be particle or wave. If you focus on the schedule, then schedule C says 400 something. Then you cannot go beyond that. And if you focus on 602, then you cannot focus on the schedule because schedule is at variance with 602.
No, no, just I want to show that although the suit was filed in respect of Schedule C, claiming eviction in respect of Schedule C, but that is not tallied with the actual tenancy. The tenancy is, was in respect of 609 square feet. That's my
argument.
Argument before you.
Defined by a specific boundary. Judgment Yes, sir. The present appeal revolves around a short question. Push up next para. The suit was filed by the plaintiff stroke appellant for eviction of the defendant stroke respondent inter alia on the ground that the respondent has been rendered a trespasser and seized CEACD to be a tenant by virtue of the moratorium specified in section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Full stop. The learned trial judge, despite holding all issues in favor of the plaintiff, refused to grant a decree of eviction on the premise that it is an admitted fact that the defendants are in possession of 609.32 square feet and the plaintiff, by dint of deed of conveyance within bracket exhibit A bracket closed, purchased 432 square feet. Full stop. Therefore, according to the learned trial judge, even if a decree of eviction is passed in favor of the plaintiff, the plaintiff is entitled to get back only the area which he has purchased as per the deed of conveyance within bracket exhibit capital A bracket closed, which, according to the learned judge, tantamounts to splitting the tenancy of the defendants, which is not permitted by the 1997 Act. Full stop. Next para. Learned counsel for the plaintiff stroke appellant places reliance on the relevant paragraph, that is paragraph number 2 of the plaint and the schedule to the plaint, to indicate that the suit property, in respect of which, according to the plaintiff, tenancy was granted to the defendants, was confined to a godown on the ground floor premises, on the ground floor at premises number 127 capital A stroke 1, Acharya Prafullo Chandra Road. Full stop. Tallying the description in the suit, description of the property in the schedule of the plaint with schedule capital C of the sale deed within bracket exhibit A bracket closed, by virtue of which the plaintiff claim title, learned counsel for the appellant argues that the two exactly reflect each other. Full stop. Schedule C of the sale deed clearly specifies that the measurement of the said property is 432 square feet built up area with extra 20% super built up area. Full stop. Next para. Learned counsel further places the written statement of the defendants to show that the defendants stroke respondents never disputed the identity of the suit property. Full stop. Although, in two stray statements made in the evidence in examination in chief, the defendant's witness stated that the suit property, that the tenancy was of 609.32 square feet, it is argued by learned counsel that the same, being dehorse the pleadings, could not have been looked into by the learned trial judge at all. Full stop. Next para. Learned counsel accordingly argues that the impugned judgment and decree be set aside, and the relevant portion of the impugned judgment and decree along with the findings consistent therewith be set aside, and a decree of eviction be granted to the plaintiff. Push up next para, learned counsel appearing for the respondent contends that in an order dated April 29, 2003, passed in CO number 2692 of 2002 by a learned single judge of this court in connection with a revisional application under section 115 of the Code of Civil Procedure, it was recorded that the area of the tenanted premises was 609.32 square feet. First up, the said order having not been challenged before any superior forum, it is argued, binds the parties. First up, next para, learned counsel for the defendant stroke respondents next places reliance on Exhibit 3, the eviction notice dated February 3, 2011, which preceded the filing of the suit and furnished the cause of action for the eviction suit. First up, it is argued that in the said notice, the plaintiff clearly mentioned the area of the tenanted premises to be 609.32 square feet. First up, next para, it is, thus, argued that both parties proceeded on the presumption that the area of the tenanted premises is 609.32, which is beyond the area for which eviction has been sought. Push up next para. It is further pointed out that in the impugned judgment, the learned trial judge took notice of Order 6, Rule 2 of the Code of Civil Procedure, but nonetheless, proceeded to pass the impugned judgment and decree. Push up next para. Upon a careful perusal of the materials on record and hearing learned counsel for the parties, we arrive at the following conclusion, next para. Insofar as the description of the tenanted premises to be 609.32 square feet in the eviction notice is concerned, the same is palpably a misdescription, since the subsequent plaint filed by the plaintiff clearly belied the said measurement of the tenanted premises by specifically describing the suit property to exactly tally with Schedule C of the purchase deed of the plaintiff. Full stop. Next para. Notably, the defendants, in the written statement, did not mention a single statement denying the identity of the suit property as described in the plaint. Full stop. In the evidence in chief of PW1, two statements were made which may be germane in the context. Full stop. In paragraph 14 of the said examination in chief, it was stated that when City Civil Court did not grant relief to the predecessor in interest of the defendants to raise walls in order to protect the tenancy, the Honorable High Court was moved when a learned single judge by an order dated April 29, 2003 gave the predecessor in interest of the tenants liberty to protect his tenancy area double inverted of 609.32 square feet double inverted close by constructing boundary walls of his tenancy. Full stop. It was further stated that after passing of the said order, the predecessor within bracket father bracket closed of the tenant constructed boundary walls as permitted by this court in order to protect his tenanted area of 609.32 square feet, and that the tenants still occupied the said tenancy, protecting the tenanted area of 609.32 square feet. Full stop. Next para. In the very next paragraph of the examination in chief, comma, it was stated that the plaintiff has alleged in his deed of conveyance that he has purchased only 432 square feet area, which is only a part of the alleged tenancy, which is admittedly 609.32 square feet. Full stop. Next para. The first thing which strikes the eye, EYE, is that the said statements made in the examination in chief partially speak about an order passed by a learned single judge of this court and partially assert the tenanted area to be 609.32 square feet. Full stop. However, comma, such assertion is palpably at variance with the pleadings as made in the written statement of the defendants. Full stop. In terms of the Code of Civil Procedure, comma, the pleadings comprise only of the plaint and the written statement, and as such, comma, we cannot look into other documents to cull out, CULL, cull out the pleadings of the defendants. Full stop. Having not challenged the identity of the suit property as described in the plaint and or the area of the premises as depicted in the in the plaint schedule or schedule C of the purchase deed of the plaintiff, comma, it did not lie in the mouth of the defendants to deviate from such stand taken in the written statement and challenge the area of the tenancy. Full stop. Thus, comma, the learned trial judge acted erroneously in law in looking into the statements made by the DW1 in evidence which is at variance with the pleadings. Full stop. Order 6, Rule 2 of the Code of Civil Procedure, comma, which was considered by the trial court, comma, merely relate to the pleadings and what they should state. Full stop. Next para. The said provision has no connection with the proposition which is well settled in Indian courts that there cannot be variance between pleading and proof. Full stop. Next para. Insofar as the eviction notice is concerned, comma, the same is obviously a misdescription, comma, since the subsequent pleadings of the plaintiff in the plaint correctly describe the suit property to tally with schedule C of exhibit A, which is the purchase deed of the plaintiff, comma, describing the said property to be the tenanted premises, comma, which was never disputed in the written statement by the tenants. Full stop. Schedule C clearly depicts the measurement of the property to be measurement of the tenanted premises to be 432 square feet, and as such, comma, the court could not look beyond the same in passing the impugned judgment and decree. Full stop. Next para. Insofar as the stray observation in the order dated April 29, 2003, passed by a learned single judge in CO number 2692 of 2002 is concerned, comma, the said revisional application itself arose from an interim order passed in the suit in respect of construction of a wall. Full stop. Next para. Such revisional application, comma, thus, comma, is confined to the effects of the order impugned therein, and having been passed during pendency of the suit, comma, cannot have any material bearing or binding effect at the final adjudication of the suit, comma, when the learned trial judge took into consideration the entire pleadings and evidence as well as arguments of parties and adjudicated the issues involved finally. Full stop. In any event, comma, the said revisional court's order does not reflect any arguments on the issue as to the actual area of the tenanted premises, and as such, comma, in any event, comma, could not have been a binding precedent on the issue of the measurement of the tenanted premises. Full stop. As discussed above, comma, the measurement of the premises was a non-issue in the suit, comma, having not been disputed at any point of time in pleadings by the tenant. Full stop. Next para. As such, comma, the mere misdescription of the measurement in a preceding eviction notice does not affect the outcome of the suit, comma, since in any event it is another well-settled proposition of law that if both the parties understood the purports of a notice, comma, a mere misdescription does not vitiate the same. Full stop. Next para. In view of the above discussions, comma, we are of the opinion that the learned trial judge palpably erred in law in holding all in refusing to grant a decree of eviction against the defendant stroke respondents, despite having arrived at all despite having decided all other issues in favor of the plaintiff stroke appellant. Full stop. As such, comma, the finding as to splitting of tenancy is palpably dehors the dehors exhibit A, comma, the purchase deed of the plaintiff, comma, which clearly shows not only the extent of the tenanted premises to tally with the suit with the plaint description, but also indicates that the plaintiff was the owner of not only 432 square feet, but of an area much more than that. Full stop. Next para. Hence, comma, in any event, comma, the learned trial judge proceeded on an erroneous footing in refusing to grant an eviction decree on the non-applicable proposition of splitting of tenancy. Full stop. Next para. Accordingly, the impugned judgment and decree cannot be sustained. Full stop. Hence, the appeal succeeds. Full stop. FA number 229 of 2022 is hereby allowed on contest, comma, thereby setting aside the judgment and decree dated September 17, 2022, passed by the learned judge, comma, second bench, comma, City Civil Court at Calcutta in title suit number 257 of 2019, and granting a decree of eviction in favor of the plaintiff and against the defendant stroke respondents. Full stop. The defendant stroke respondents shall hand over vacant and peaceful khas possession of the suit premises in favor of the plaintiff stroke appellant, and or the duly authorized representative of the plaintiff stroke appellant within 3 months from date. Full stop. Have you levied execution? Oh, sorry. In default, comma, the plaintiff stroke appellant will be at liberty to levy execution of the present decree.
Not the mean profits.
Mean profits were sought for.
Paid for, so that's B. Damages or mean profit.
But that was never considered also.
No, because suit was dismissed, there was no question of mean profit.
Then we'll remand it for a limited period. For that limited.
As for mean profits, it has to go back.
Yes.
Yes.
It has to go back.
Yes, it has
I will
to
get a degree, then
So next para. Insofar as the যেখানে বলে levy execution in respect of eviction বলে বাকিটা যাব. Next para. Yes, separate cannot be confused.
Yes, it is basically in respect of 2G, expiry of the period of 5 years.
But the trial judge didn't consider that at all. Let it be considered, and you will be entitled to argue that. Insofar as the question of main profits is concerned, comma, the matter is.
We don't need main profits.
That's very well. Prudent. Formal decree be drawn up accordingly.
I was wondering, my lord, your lordship has set aside the entire order, degree, judgment, but there are just
Findings cannot be,
Things cannot
we
be.
cannot dissociate the two. We are thinking of that also while passing the judgment, but we cannot dissociate findings from that. But we have observed in several places,
Yes,
so that has merged in this,
yes,
and concurrent finding of that
Yes.
court and our court that those we are not
issues
disturbing
were
those.
fine.
Yes. Otherwise, we couldn't grant the decree.
That is exactly, my lord. Very
A formal decree be drawn up accordingly. Last line. Thanks. Thanks. আরেকটা line add করে interim orders if any stand vacated. Interim orders if any stand vacated. Thanks. Definitely.
grateful to that, so so grateful.
আর কি এটাতে লিখলাম একটু টাইম পাস হয়ে যাবে
But item 20,
Yes.
before the petitioner starts, may I just indicate
Yes.
that I'm beg to appear on behalf of the respondent. Yesterday only I was made aware of this matter. I could not even trace out the file, that is the paper book, my lord. I will be praying for some time be granted to me so that I myself be of any assistance before this honorable.
No, definitely we want your assistance. We'll give you a week, not more than that. You are getting a long weekend.
Kindly fix it to Wednesday.
Hand over a copy of the paper book to him.
They have served us a copy long back.
This song,
If I will be trying to search that by over this weekend, if I don't, I will address them a later on Monday itself so that an extra copy I can get.
Monday won't help you. Do this. Just take out a photocopy of the paper book, hand it over to
I have
him.
a scan copy, then mail it.
Provide a scan copy, yes, soft copy, and you will take a print out.
I have a scan copy. Kindly fix it on Tuesday, my lord. Wednesday, my lord.
We'll keep it on
Wednesday, my lord. Actually, my lord, this matter
Wednesday.
is
Then very well, he gets more time. Wednesday.
Grateful, my lord.
Learned counsel for the respondent submits that he is in some difficulties since the paper book could not be traced out in his office immediately. Full stop, next para. Accordingly, on the prayer of the respondents, the matter is adjourned till November 20, 2024, when it will be listed under the same heading. Full stop. In the meantime, the learned advocate for the appellant shall forward a scanned copy of the paper book to his counterpart appearing for the respondents. Thank you.
Item 21.
Lord,
Yes.
Should I appeal for the respondent?
How many minutes for this? More than that. More than. Yes.
Lord, I am for the appellant.
Yes, Mr. Ghosh. What is the matter?
Lord, the defendant.
Give us half a minute. Let us get the paper. পেপার বুক নেই দেখ শুনবো রেডি আছে Yes, Mr. Ghosh, what is the matter?
For the food for declaration and for permanent injunction. I am the defendant.
Right.
Lord, the declaration to that effect that earlier partition between the parties is not binding upon them, and so this earlier partition deed must be declared as a null and void.
Give us half a minute. এই শুনুন না বলছি এই বড় সিপিসি গুলো declaration that
the previous
partition suit was
deed that is null and void.
Partition deed or degree?
Partition deed.
Null and void.
Null and void, not binding upon the plaintiff.
Why not?
Why not? Because the other heirs were not made the party according to them. And Lord, the further relief was that the partition.
Yes.
Lord, there is a complicated facts. Lord, to understand the fact, kindly come to page 94. Lord, my lord will find from top Indumoti. Indumoti, Mollik. At top.
Indumoti, yes, top.
Yes.
Right.
Indumoti and Narayan Chandra Rokhit, right hand side.
Right.
These two persons purchase the suit property. And this is not in dispute.
They're the joint owners.
Joint owner.
Very well.
Now, this chart has been prepared by my learned friend, that is the plaintiff. That Indumoti died, leaving behind Gopeshwar, son, and Lolita Mollik, daughter.
Yes.
Next, Lord, the Gopeshwar died, leaving behind the 6 legal heirs, who are the defendant appellant before your lordship. Now, Lord, according to plaintiff, Lolita died, leaving behind 2 daughters, Kamala Rokhit and Ostukana Das Rokhit. Then, according to them, Kamala married the Narayan, who had the at top. My lord will find from top, who had the 50% share. Now, the Kamala and Narayan both died. That is why Narayan's 50% share will come under devolved upon the Durga Chakraborty, and Durga Chakraborty will further get from their grandmother Lolita.
All right.
My case, this is the plaintiff case. My case is this.
Who is the plaintiff? No, who is the plaintiff in this?
Plaintiff is the Kamala Rokhit and Durga Chakraborty.
Yes. Right. Then
mother and daughter.
Your case is that?
My case is that Indumoti and Shivkishto died, leaving behind only one son, Gopeshwar.
You deny Lolita?
I denied Lolita. So therefore, whatever the share.
You say there was no Lolita at all?
There was no Lolita at all.
All right.
So this part, the Lolita's heirs are entitled to receive the Narayan's property only.
All right.
This is my case. Now, Lord, kindly come to impugned judgment. Before coming to impugned judgment, Lord, there are.
Then Gopeshwar gets more.
Gopeshwar get more, according.
Much more, because Lolita's 1/4 is no longer there. Then Gopeshwar gets.
Gopeshwar will get
half.
50%.
Half. Yes. 50%.
50%. And rest 50% that
distributed among Kamala and them.
Kamala and Durga, during pendency of the case, Kamala died. So that is why the Durga will only get the property. Now, Lord, kindly come to impugned judgment.
Mr. Ghosh, what sort of a paper book is this? The cover does not mention the impugned judgment. Order number dated such passed by Honorable Justice Harish Tandon and Justice Abhijit Gangawat. That is the impugned order.
Absolutely my mistake, Lord. I tender.
You should have checked up personally.
I tender apology. Tender apology, Lord.
Anyway, so where should you go now?
Now, Lord, kindly come to page 184.
Yes.
Lord, according to me, these are the 4 issues are important for adjudication of the appeal. First, issue number 4. Whether the suit is bad for partial partition or previous partition. Issue number 8. Whether Lolita is the daughter of Indumoti and Shivkishto Mollik, whether the Lolita has the 2 daughters named Ostukana and Kamala.
Lolita's existence, there is no issue on that. You say there was no Lolita at all.
There is no Lolita at all.
Framed in a different manner.
Yes.
Achha, why partial and previous partition clubbed together? If the previous partition took place, over and above that property, they have also claimed that there are other joint properties.
No, only this proportion, sole property.
Anyway, this is framed in a peculiar manner. Whatever. Yes.
And issue number 12 and 13.
All right.
Now, Lord, before coming to issue number 8, Lord, I am just addressing your lordship issue number 13,
Limitation.
limitation point.
All right.
Page 222.
Yes.
Lord, the paragraph 4.
Hmm.
I'm placing that paragraph. Now, whether the suit is barred by law of limitation is to be discussed. The point of limitation is the mixed question of fact, law and fact. To determine the case, the court is to first see whether the what relief has been sought for. This is not a simpliciter suit for declaration that the impugned deed of partition is void. If it is a simple suit for declaration, declaring the impugned partition deed is void, the plaintiff is to come within 3 years from the date when the fact entitling plaintiff to have the deed cancelled first known to her. This is the fact. This is a suit for partition and declaration. Partition is the main relief and the declaration is the consequential relief.
You say it's the other way around.
I said this is the other way.
Because if the deed stands, then
My
there
lord,
cannot be.
I grateful. This is my case.
Hmm.
That was the gateway of the plaintiff. Unless until this portion is hurdle is passed through, he cannot seek for partition. Because the impugned deed is void, having no binding effect upon Kamala and Osrukana, the oral evidence of PW1, the Kamala Rokit reveals her position in the suit property. So the plaintiff need not to have prayed for declaration that the partition deed is void, and without seeking such relief, she could directly claim the partition, and as such, partition is the main relief in the suit. Now, why the plaintiff sought for such declaration if it is not necessary? Answer is, said partition deed cast a cloud over the title of the plaintiff. Declaration creates no fresh right, it just removes the cloud cast it upon the fact which is all alone in existence. Furthermore, neither Kamala nor Osrukona were made party to the impugned deed, and so they need not to have prayed for its cancellation. Moreover, Article 59 of the Limitation Act is not applicable to void transaction. So there is no question of holding that suit is barred by law of limitation. Point of limitation being the mixed question of fact and law, the court should not read the oral evidence of PW1. Not the PW evidence I will indicate from the records, but she said that she had the full knowledge. On the day of registration, she was present at the registry office. That deed of partition executed in the year 1979, and suit was filed after long back.
Her share was also decided in that partition.
My lord, she was the first plaintiff.
But if she was not a signatory, but you said she admitted her presence and knowledge.
Yes.
All right, we'll see that later.
As to her knowledge about the impugned deed, as pointed out by learned advocate for the defendant, in isolation and in disregard to the position of the law as to ineffectiveness of the impugned deed. So, this court is to accepting the argument of the learned advocate for the defendant in this case. Case law as cited by the learned advocate for the defendant reported and such are not applicable in the present context of the case. Thus, the court find and hold that suit is not barred by law of limitation. Suit is maintainable in respect of maintainable in all respects, and the issue number 13 and 1 are decided in favor of the plaintiff. So, Lord, Lord, kindly come to the evidence of PW1. Page 101.
Kamala cannot lose in both places, in USA and India.
My lord.
Yes. Which page?
101. Lord, page 101. Lord, straightway kindly come to first page 103, middle portion. In the bold word, it was recorded.
This is the continuing cross-examination of
My
Kamala.
lord, my lord. My lord has got
bold. Yes.
bold. I have signed upon the partition deed. That is the exhibit B, which is under challenge.
But she did not sign actually.
Perhaps she signed as a witnesses. That is the. I have signed upon the partition deed at the first week of April 1979. It's cross-examination. At afternoon at Alipur, I along with Gopeshwar Mollik and my husband Narayan Rokit went to concerned registry office. It has been taken an hours to complete the registration process. The expenses of the registration work has been bared by my maternal uncle Gopeshwar Mollik. We all alone returned after registration. I do not know whether the shoot land has been mutation or not. Now, my lord, kindly come to further cross-examination. I do not know whether the shoot land has been mutated or not. I do not know whether the tax has been paid in connection with the shoot land or not. Defendant has been, this is the knowledge.
Which page? 10?
103. I am continuing.
You continue. Right?
Yes. Defendant has been possessing half share of the shoot property. Rest half share belongs to us. We and the defendant have been residing at the shoot property since 1958. That is more than 50 years. Narayan Rokit during his lifetime never wrote a letter to Gopeshwar Mollik or his legal heirs of the Gopeshwar Mollik as his signature on the such partition deed was taken by force. Narayan Rokit during his lifetime never complained to any court or registry office that his signature was taken up on the partition deed by way of force. I did not file any suit before any court of law challenging the partition deed. The letter dated 31st October 2012 bears no signature of the defendant. That is the demand justice blood for seeking repartition. This is the knowledge of the PW1. Our learned judge has held that in a suit for partition and for declaration, partition is the substantive relief and the declaration is the ancillary relief. That finding is wrong according to me.
But an attesting witness need not have knowledge of the contents. She went as an attesting witness. But the other portion is possessing half share.
He is claiming Kamala PW1, he may be attesting witnesses, but kindly consider.
She doesn't say she knew about the contents of the deed here. She said, I went to the registry office, signed, whatever.
But he did not raise any objection for last this long time.
But in law, attesting witness need not even know the contents. She has to see whether the executant is signing it. Attesting means only she attests the signature. Knowledge of the content cannot automatically be attributed unless there is independent evidence to show that she had knowledge. But you may argue the next sentence, defendants have been possessing half share, rest half share belonging to us, which is in consonance with your statement.
My lord. And lord,
if partition decree was that deed was given effect to, then it would not be half.
My lord, grateful to lordship.
So that sentence is crucial, maybe.
Next, lord, kindly come to the examination of PW5. That is that second defendant, second plaintiff. Page 140. 140, my lord.
Yes. PW5.
PW5. Page 142. Kindly come to stateway page 145. 142.
Yes.
Lord, the middle portion. Without wasting my lord's time, I'm coming to middle portion. We are residing in the western side of the shootland. Defendant are residing in the eastern side. There is a brick wall over the shootland. In one side, there is a land measuring about 2 kathas and few chodak, and another side, there is a land measuring about 2 kathas and few chodak. It is a partition wall between the two houses constructed in the year 1958. Lord, I am putting this question to myself, unless until Lord, the exhibit B was not acted upon, these things could not have been taken place.
All right.
So, Lord, the moment he has prayed for declaration of the deed of partition is a void, Lord, it will be regulated under the Limitation Act within 3 years from the date of knowledge.
So these are your arguments on the main issues as well as limitation,
My lord.
because you say that merely by saying that if it's void, admittedly all parties were not signatories, it's void, therefore no declaration is required. That was the premise of limitation holding,
My lord, yes.
negating limitation. But you say no, as per the evidence, if the evidence was looked into, there was sufficient proof of that document, execution of the document, therefore it cannot be said that it was automatically void, declaration was necessary.
My lord.
If necessary, then 3 years apply.
Then 3 years.
And also on merits, these are proof that document was acted upon.
My lord.
All right.
That means the Lord Kamala is the Lord, the PW1 had the knowledge, PW5 had the knowledge. Who are the first plaintiff and the second plaintiff?
All right.
Now, Lord,
there are only 2 plaintiffs.
Two plaintiffs.
Right.
First plaintiff died. That is why the second plaintiff inherited the entire share. Now, Lord, kindly come to issue number 8. Issue number 8.
Yes.
Whether the Lolita is the daughter of Indumoti and Srikishto Mullik, and whether Lolita had the daughters, namely Oshtukana and Kamala Rakshit. But this issue was decided by the learned judge basing upon the oral evidence of PW3 and 2 documentary evidence, that is Exhibit 11 and Exhibit 19.
All right.
Lord, before addressing this issue, Lord, I am submitting one things that will be argued by my learned friend. Lord, in my written statement, there was an admission that yes, Gopeshwar had a sister. But subsequently, that written statement was amended.
That was allowed.
That was allowed. That order was not challenged. Learned judge has held in the order impugned that judge will not consider, learned judge will not consider post-amendment fact.
Post-amendment pleading.
Post-amendment pleadings. Now, Lord, kindly come to issue number 8. Lord, kindly come to page 193 without wasting my lord's time. Paragraph 2.
Yes.
In
so,
respect,
Mr. Ghosh will continue after recess.
Lord, after recess, Lord, I have a fixed matter, court number 5. Lord.
That will be over till before that he will be continuing.
only one request. If it doesn't get over, my lord, he will conclude, but I'll reply on Monday.
Very
Eh, kindly comment. Sir.
Keep someone.
Yes, yes.
Yes.
Come on.
We'll come back at 2. এগুলো থাক, দুটোর পর আবার কন্টিনিউ। Yes.
Lord, I was addressing the issue number 8.
Right.
Lord, the issue number 8, Lord, I concluded that regarding the amendment, that there was an amendment, there was an admission.
You are placing page 193.
193, paragraph 2.
Right.
The learned judge has held this court should look the pleadings as stood after amendment. Last line. Paragraph 2, last line.
Yes, after amendment, the admission was withdrawn.
Huh.
Yes.
Next, Lord, the paragraph 34.
Yes.
To prove the existence of the Lolita and her two daughters named Ostukona and Komala Rokhit, learned advocate for the plaintiff next rely upon advocate for the plaintiff next pointed out the oral evidence of PW1, that is Lokkhikanto Mondol. Milord, who is Lokkhikanto Mondol? That has to be indicated from the chart. Kindly come to page 94. Lord, page 94, my lord, has find the Lolita husband was Jugal Kishore Mollik. Jugal Kishore Mollik, second wife son. PW3. Jugal Kishore's second wife sons.
Yes.
Now, Lord, kindly come to page 93, paragraph 34. He submitted that PW3 Lokkhikanto Mondol is the son of Jugal Mollik, and he stated in his evidence that his first wife of his father, Jugal Kishore Mollik, was Lolita Mollik. He also relied on Exhibit 19 series. The later given information on the basis of application under Right to Information Act and the yearship certificate of the affidavit supplied with the said letter. Said chairman of the Ghatal municipality has given a rely to the there should be the reply to the application under the Right to Information Act, and the chairman has also supplied one heirship certificate of the Jugal Kishore Mollik and one affidavit shown by Lokkhikanto Mollik to plaintiff's advocate, whereupon it will be appeared that Lokkhi Mollik was the first wife of Jugal Kishore Mollik. But the entire issue was decided whether the first wife of Jugal Kishore Mollik or not. But the issue framed was that whether the Lolita was the daughter of Indumati. But the evidence came before the court whether the Lolita was the first wife of Jugal Kishore Mollik or not. Next paragraph, plot the paragraph 35. Learned advocate for the defendant raised objection and submitted that the said letter giving information under Right to Information Act and the documents supplied herewith are annexed have not been properly proved and not admitted into evidence properly. So the court should not have considered the said document. Exhibit 19 series. According to him, mere marking of document as exhibit is not sufficient to prove the document. Neither chairman of Ghatal municipality was examined, nor heirship certificate attached thereto was genuine document, nor the copy of affidavit attached thereto can be termed as evidence. So, according to him, Exhibit 19 should be discarded. He relied upon judgment so and so, so and so. Next, Lord, paragraph 35. He submitted that Exhibit 19 is out of pleadings. And so it cannot be looked into. He relied upon the judgment reported on such and such, such and such. Learned judge has recorded certain judgment. Then, Lord, they kindly come to page 196. Now, this court is to consider whether the plaintiff could prove the exhibit 19 series and the contents therein. And the existence of Lolita Mollik and his two daughters named Ostukona and Komala Rokhit. As per the version of the oral evidence of PW3, Lokkhikanto Mollik, his father's first wife was Lolita Mollik. The PW3 was the cross-examined at length, but the issue was something different. During his cross-examination, PW3 stated that he was born in 1946, that he has document to show that Lolita Mollik was the first wife of Jugal Kishore Mollik, that he has not born at the time of the marriage, their marriage. He had not seen the Lolita Mollik. In cross-examination, he is found to be firm and strict on the point and say the truth that he was not born at the time of the first marriage of his father, Jugal Kishore Mollik, and he had not seen the Lolita Mollik. The son of the Jugal Kishore Mollik.
Obviously, he was not born.
He was not born.
He could not have been born because he is the son of the second wife.
Yes. The son of the Jugal Kishore Mollik is the best person who can state truly about his mother or stepmother if any of the marital status of the father of the Jugal Kishore Mollik, no inimical relation between the PW3 and the defendant has been pointed out during his cross-examination. PW3 stated that the Lolita is the first wife of his father Jugal Kishore Mollik. Therefore, on the demise of the Jugal Kishore Mollik, his property, if any, would be devolved upon the legal heirs of the Lolita Mollik, named the Kamala and Ostrukona. On their demise, their share, if any, would devolve upon the subsequent legal heirs of Kamala and Ostrukona, and meaning thereby the share of the PW3 would be less if he admits the Lolita to be the first wife of his father, Jugal Kishore Mollik, father Jugal Kishore Mollik. Despite the fact, PW3 went on saying that his father's first wife, Lolita Mollik, as the PW3 is giving evidence against his own interest, it can be said that he is speaking truth before the court. Therefore, there is no reason to disbelieve the evidence of PW3. Now, this court is to consider. Now, Lord, they kindly come to the evidence of PW3.
Even if PW3 was accepted, then also it was beside the issue.
Beside the issue.
Because it was something else.
My lord.
Jugal Kishore's wife might have been Jugal Kishore's
My
first
lord,
wife,
my
but
lord.
not the daughter.
Grateful to Lordship. That was that is my submission. That is my submission. And that is why I am indicating the evidence of PW3.
But PW3, is there anything else than what has been discussed here? This discussion is right. This actually the PW3 said.
Yes.
Why are you placing PW3?
That to indicate these things, that the issue was something different, something.
No, but you agree that these were actually stated by PW3.
My lord.
But you argue on a different point. That it was beside the issue. That even if that evidence is accepted, then also the issue is not clean.
My lord.
Did not place the evidence of PW3 because you agree that this was the evidence.
Yes.
Or if there is something else in PW3 evidence.
No. Next, page 197, paragraph 2. Now, this court is to consider. Now, this court is to. Sorry. Now, this court is to consider the admissibility of the Exhibit 19 series. Exhibit 19 series is written information obtained under the Right to Information Act, and it was accompanied by an affidavit shown by Lokhikanto Mollik and is once heirship certificate issued by the chairman of the Ghatal municipality. It is the case of the plaintiff that Lolita is the daughter of Indumoti Mollik, and said Lolita had the two daughters, namely Ostukona and the Kamala Rokit. And therefore, the plaintiff is to adduce the evidence and the document fact provencio to prove the same. The fact constitute the facts proventia need not to be stated in the plaint. Only the fact provenda is required to be stated in the plaint. Herein, the fact that the Lolita is the daughter of Indumoti and said Lolita and had the two daughters, namely Ostukona Das and Kamala Rokit, are the fact provenda, which is required to be and mentioned in the plaint. The plaintiff is supposed to prove the same by evidence that is evidence of PW3, and other is to required to be stated in the plaint. So this court unable to accept the contention of the learned advocate for the defendant that whatever the PW3 stated is out of pleadings and cannot be accepted. Now, Exhibit 19, the information and the document obtained under the Right to Information Act is not supposed to be the possession of the plaintiff. So the plaintiff could not be blamed as to why he did not file the same at the time of filing of the plaint, or why he did not take leave to file the Exhibit 19 at later stage of the trial. The information along with the certified copy of the yearship certificate of Jugal Kishore Mollik and the certificate and the certified copy of the affidavit shown by Lokhikanta Mollik was given under the Right to Information Act. It is fact, as per the Section 3 of the Evidence Act, affidavit does not constitute the evidence. So this court is ignoring the evidence affidavit shown by Lokhikanta Mollik supplied with the RTI Information Act. One airship certificate duly certified by the chairman of the Ghatal municipality has been supplied with the Right to Information Act. Now, whether it is admissible in evidence, the answer of this point has been given in unreported judgment titled as Narayan Singh versus Coloran Swansu cited by the learned advocate for the plaintiff, wherein it was held that clause F of section 65 of the Evidence Act makes it clear that the certified copy permitted under the Evidence Act or by any other law in force can be treated as the secondary evidence. Right to Information Act, in my view, falls within the ambit of by and other law in force in law in India. The definition of right to information makes it clear that the certified copy of the document are given to the citizen under their right to obtain the information. In my view, court below has rightly opined that the document can be admitted as secondary evidence since the document are covered under section 65 of the Evidence Act and there was no need to compare the same with the original. That being the position of law, this court is inclined to hold that the airship certificate obtained under the Right to Information Act is necessary evidence and admissible. Since it is admissible as a secondary evidence, non-examination of that is the blood erroneous findings according to me. Non-examination of the chairman of the concerned municipality is not fatal. Lord, kindly see the Exhibit 19. What is Exhibit 19? Part 2 of the paper book, my lord.
Achha.
Page 330.
Yes. It was exhibit 19 series. So there are other documents also.
Lord, it was written, Lord, the if other document is there, Lord, but trial court record has to be, Lord, looked into for the Exhibit 19, Lord. I also find some discrepancy in the paper book regarding the Exhibit 19, Lord.
Exhibit 19, how has it been described?
Lord, the page 330, that is the document.
Page 331 stops at 18.
330, Lord.
Page 331, the Firisti stops at 18. 19 is not there. Oh, maybe the application under Right to Information Act and all, those were all the series.
Lord,
It must have been the query and the answer.
Answer is, Lord, page 330.
330, yes.
It was written to Manavendra Thakur. I don't know who is Manavendra Thakur.
Advocate for them.
But he is not parties to suit.
Yes.
Next, Lord, as per your kind requirement, dated such and such, under Right to Information Act, this is to inform you that the requirement of certified copy of the affidavit dated such and such, certified copy of the certificate dated such and such, regarding the legal heirs of the late Jugal Kishore Molliks are being supplied to you to your end on behalf of your client Shrimati Durga Chakraborty within bracket Rokhit, wife of Taraknath Chakraborty. Now, Lord, I am putting this question to myself whether these page 330 answer the issue number 8 or not. I am putting this question to myself, Lord.
But we have to ascertain whether this was the entire document.
Lord, that has to be considered.
Should have looked into
yes, yes. I will take care of this.
Take the lower court records and ascertain whether there were other documents.
I will take. Now, Lord, kindly consider the evidence of PW1. page 101. The continuation, page 102, last part.
Yes.
Last 3 lines. I do not have any document to prove that Lolita Devi was my mother. At the time of death of my mother, I was 3 years old. A document to prove my mother's identification may be lying at my father's house. My brother can prove this by giving the evidence. Not a fact that Lolita Devi is not my mother. Lolita Devi alleged he had no identification proof. Durga Chakraborty, that is the plaintiff number 2, was born on 20th October 1955. Not a fact that Durga Chakraborty is not the daughter of Santosh Rokshit, as I do not have any divorce with Santosh Rokshit. I do not have any document as to prove Indumoti as my grandmother. But he was the PW1 was the best person to prove his mother's existence.
But PW1 says Lolita was not her mother.
I
Not
do
the
not
fact
have,
that Lolita is my mother.
no, I do not have any document to prove.
So page 103.
I do not have any document to prove.
Page 103, the first sentence.
Not the fact that Lolita Devi is my mother.
First sentence.
Page 103. Top.
Not a fact. My lord is single.
Yes.
Not a fact. Lolita Devi is my mother.
So she denies that Lolita Devi is her mother.
Not a fact that Lolita. This is the denial was that is why the answer was given in such a way. Not a fact that Lolita Devi is my mother. Perhaps some typographical mistake is there. Perhaps.
Otherwise, she admits that Lolita is not mother.
Yes.
One not is missing. Not a fact that Lolita Devi is not my mother.
Not a fact that Lolita is my mother. Next, Lolita Devi alleged had no identification proof. Durga Chakraborty, that is the plaintiff number 2, was born such and such date. On such and such date. Now, Lord, the bold word, I do not have any document to prove the Indumoti Devi as my grandmother. That was Lord, PW1 was the best person to prove his existence.
But you have to ascertain also whether this is, you cannot brush it aside. Not a fact that Lolita Devi is my mother is a crucial piece of evidence.
Crucial piece of evidence.
You have to see the certificate, the actual evidence, whether deposition, whether that is actually there. Otherwise, it will be very crucial.
I shall tell.
If she admits Lolita was not her mother, everything goes.
Lord, may I be permitted?
LCR, yes, LCR টা
LCR টা
নোট করতে করতে আছে এখানে? তাহলে একটু আনিয়ে নিতে হবে ডিপার্টমেন্ট থেকে একবারে কাউকে দিয়ে একটুখানি এর মধ্যে আনিয়ে নিন কারণ এখানে কিছু লিস্টে কিন্তু দেখাচ্ছে আছে জানেন ওটাই কোথাও পড়ে আছে এরকম
Lord, evidence of PW1. PW3 evidence already my lord has seen from the impugned judgment. Now, Lord, the evidence of PW5. Page 140.
Yes.
national blood middle portion. I was born I was born on
Page 100?
141
51.
cross examination.
Yes, I was born.
I was born on 20th October 1955. I
Hmm.
have no personal knowledge about the above facts. I have no document to show Shivokeshto Mollik was mentally disbalanced. I have no knowledge about the statement made in paragraph 13. This is the irrelevant paragraph according to me. I have heard prior to 8/8/1953, my mother got married with another person, namely Santosh Rokit, but said marriage was not completed. On the day of Ostomongola, he left my mother permanently. Next document, next page.
Who is the PW5?
PW5 will the plaintiff 2?
Oshukana.
No, no.
Durga.
Durga.
Durga. Durga.
Yes.
Next page 142. Exhibit 17 was issued by the chairman of the Ghatal municipality. I do not know his name. On the basis of RTI, Exhibit 17 was issued.
Exhibit 19 was that document.
Blood there was a blood erroneous blood recording that was also the
What
learned
is
judge
true?
has
17?
corrected.
17 is correct or 19 is correct?
19 is correct. Lord, the learned judge has corrected in his order. Kindly see, Lord, the form. I am reading the Lord, page 142. My Lord, will find the learned judge has corrected these things. Page 182. Exhibit 19. Reply on the basis of application under right to information and the document supplied thereon. Though it has been inadvertently marked as Exhibit 18, but it should, sorry, 17, but it should be read as 19.
All right.
On the basis of our RTI, RTI Exhibit 17 was issued. In our RTI, we have prayed for issuance of the legal heirship certificate. It was served upon us through the registered post. I cannot say at this stage whether we should bring the chairman of the Ghatal municipality as witness. I can confirm it on the next date. I do not have any document. I do not know anything about the family member of Santosh Rokit. I know the Narayan Rokit, but I cannot say how many brothers and the sisters he had. Nandagopal Rokit and Siddheshwari Rokit were his father and the mother. He used to reside at Pekipara, Paikpara, Kolkata. I never seen Lolita Mollik. I never seen Lolita Mollik. I have no birth certificate or any other document of her. I have no document of the heirship. So, Lord, regarding exhibit, regarding the issue number 8, Lord, the PW3, who is the outsider, he gave the evidence something different other than the issue. PW1, who is the daughter of the Lolita, he could not prove the existence of his mother, that his mother was the daughter of Indumati. Next, Lord, his granddaughter, that is PW3, who was the plaintiff number 2, she also could not prove the existence of the Lolita. Now, Lord, the learned judge has relied upon the Exhibit 19. The Exhibit 19 is altogether beyond the pleadings. Lord, I was not given any opportunity to examine the scribe of the Exhibit 19. Exhibit 19 was not brought in, scribe and the person who prepared the Exhibit 19 was not brought on.
The author never
No,
came to
Lord.
prove it.
He was not. Lord, the fair trial and opportunity of hearing was denied there. And the learned judge has said, because of this is the secondary evidence, need not to be examined. It is the findings of the learned judge. So regarding the issue number 8, this is my submission. Now, Lord, issue number 12. the issue number 12 was whether the deed of partition being numbered is legal and valid. Issue number 12. But according to me, issue number 12 and issue number 4 are interrelated. Because the previous partition last part
Yes.
interrelated. So I am addressing both the issue number 4 and 12 together. Page 211. Paragraph 47 onwards.
Yes.
Learned advocate for the defendant further pointed out that at the time of execution of the Exhibit 1, the said deed being numbered so and so, Indumoti and Naran Mollik paid part consideration and promised to pay the rest part of the consideration along with the interest to the vendor. Amalgamated Development Limited, a joint stock company, within 10 years, and by this time span of 10 years, Indumoti died, and Gopeshwar and Narayan jointly paid the part consideration money along with the interest, and got the A schedule property released in their favor. Learned advocate for the defendant placed reliance upon Exhibit C, the release deed being numbered such and such, executed by and between Gopeshwar Mollik and the said joint stock company, wherein and whereby half share in the A schedule property of the plaintiff was released in favor of Gopeshwar Mollik on payment of balance consideration money with the interest, and therefore Gopeshwar became the owner of half share of the A schedule property, and the property of the plaintiff and no other heirs of Indumoti, if any, would be entitled to said half share of the A schedule property of the plaintiff. Learned advocate for the plaintiff raised objection and submitted that for non-payment of the balance consideration amount with interest, while the said joint stock company attempted to put the A schedule property of the plaintiff on auction, Gopeshwar informed the said matter to Naran, and the plaintiff number 1, Kamala Rokhit, since deceased, took financial help from the family of the father-in-law of the plaintiff number 2, and the plaintiff number 2, Durga Chakraborty, and sold some of her Stridhan articles and arranged fund, and with the said fund so arranged, Narayan Rokhit got the said property released from their joint stock company, and it was mutually released in favor of Gopeshwar Mollik and Narayan Mollik. Now this court is to consider whether the Gopeshwar acquired title of half share in respect of the A schedule property of the plaintiff by dint of the deed of release being numbered such and such, Exhibit C. It is admitted fact that at the time of purchasing the A schedule property, part consideration money was paid to the vendor, Amalgamated Development Limited, joint stock company, and the balance consideration money was promised to be paid with interest within 10 years, and Indumoti and Narayan Rokhit jointly executed the security deed in favor of the said joint stock company, and on the self-said date, as per the section 54 of the Transfer of Property Act, it is lawful to pay the part consideration amount and promise to pay part consideration amount in future under the sale transaction. On perusal of Exhibit 1, this court find no clause in the said deed to the effect that unless full consideration money with interest is paid, the ownership of the property will not pass to the vendee from the vendor. Unless such clause is there, it can definitely be said on the date of registration of the Exhibit 1, the ownership in respect of the scheduled property of the plaintiff was passed to the vendee from the vendor with effect from the date of execution, and in respect of the unpaid part of the consideration money, vendor had a charge over the said property, and so when the charge was made up by paying the balance consideration with interest, there is no question of passing the title afresh from the releaser, joint stock company, and the releaser Gopeshwar and the Narayan. Moreover, it is settled law that deed of release or relinquishment confers no title. Gopeshwar at best can claim contribution from the remaining heirs of the Indumati, as he had paid the half share of the balance consideration money with interest to the said company, but the defendant did not prefer any such claim. Rather, they have claimed to have the acquired ownership for getting the suit property released, which is impermissible in law. So, this court find and hold that Gopeshwar Mollik, this court find and hold that Gopeshwar Mollik never acquired title in respect of the half share of the A schedule property of the plaintiff for payment of the balance consideration amount and the money with the interest and getting the suit property released from the said joint stock company. This court is further find that the find and hold the Indumati and Narayan jointly acquired right title interest in respect of the A schedule property of the plaintiff. Next page, paragraph 49, learned advocate for the plaintiff next submitted that impugned deed of partition was fraudulently obtained by Gopeshwar by practicing undue influence, fraud, coercion, misrepresentation, so it is void. The impugned deed of partition, Exhibit B, it is void ab initio as the co-owners named Kamala Rokhit and Ostukona have not been impleted as the party to the said impugned deed of partition. So, he prays for declaration that impugned deed of partition being Exhibit B is void document. By virtue of the impugned deed of partition, neither Gopeshwar nor his heirs, defendant number 1 to 6, acquired share in the suit property. According to him, Indumati and Narayan had half share each in the suit property. Indumati had two legal heirs, namely Gopeshwar and Lolita, and the half share devolved upon the Gopeshwar and the Lolita, and such Gopeshwar and the Lolita both have 1/4 share in each in the suit property. On the death of the Gopeshwar, defendant number 1 to 6 inherited 1/4 share in the suit property. Lolita died, leaving behind the Ostukona and Kamala, and her half share devolved upon the Ostukona and Kamala in 1/8 share, and the said 1/8 share of the Ostukona devolved upon the pro forma respondent number 7A to 7B, Shiv Shankar Das and Bonolata De. Narayan Rokhit died, leaving behind the Kamala Rokhit and Durga Chakraborty. Said half share of the Narayan devolved upon the Kamala and Durga in 1/4 share each. Share of the Kamala stood 1/8 share from her mother and 1/8 share from her husband. Total 3/8 share, and the Kamala died, leaving behind the daughter Durga Chakraborty, and therefore the share of the Durga Chakraborty 1/4 share share from her father, 1/8 from her mother, total 5/8. According to the learned advocate for the plaintiff, he proved the case and the suit should be decreed. Learned advocate for the defendant raised objection and submitted that Gopeshwar and Narayan got the said property release and acquired the right title interest in the said suit property equally, and therefore they entered into partition deed being Exhibit B and got the said suit property partition, so it is valid. He further submitted the plea of fraud and the coercion cannot coexist at the same time. Learned advocate for the defendant next submitted that during the lifetime of Narayan Rokhit, his so-called legal heirs did not challenge the impugned deed. Narayan and Kamala used to reside together And so Kamala had her knowledge about the impugned deed from the date of execution, that is from 7th April 1979. Ostukana Das, pro forma defendant number 7, and Durga Chakraborty, being close to the Kamala Rokhit, they had also the knowledge about the impugned deed of partition. Despite the fact plaintiff did not come within the 3 years from the date of knowledge about the impugned deed, the defendant have been and are possessing half share of the suit property since 1979, and fact of the possession makes the plaintiffs aware about the defendant's deed. Despite the fact the plaintiff did not come within the 3 years when the fact entitled the plaintiff to have the partition deed cancelled, learned advocate for the defendant pointed out following the cross-examination of the PW1. PW1 Kamala Rokhit stated that she had signed the partition deed at the first week of April 1979 at the afternoon at Alipur. she, she alone with Gopeshwar Mollik and her husband Narayan Rokhit went to concerned registry office. It took an hour to complete the registration proceeding. Gopeshwar Mollik bore expenses for the registration of the said deed. They returned from the registry office. Defendant have been possessing half share to the suit property. The remaining half share belongs to Kamala. Drawing the attention of the court towards the above mentioned oral evidence, learned advocate for the defendant submitted that the Kamala Rokhit and the other had knowledge about the impugned deed from the date of its execution of the registration. Despite the plaintiff did not come within the 3 years from the date of fact, entitling plaintiff to filing the suit for setting aside the partition deed. So the relief declared is relief of declaration is barred by Article 59 of the Limitation Act. Though this is the suit for partition, but without granting the declaration, declaring the impugned deed of impugned partition deed is void, court cannot grant the decree of partition. So declaration is the main relief and the partition is the ancillary relief. As the relief of declaration is barred by law of limitation, entire suit is barred by law of limitation. He placed reliance on judgments such and such, wherein it was held the suit challenging the sale deed on the ground of being null and void is to be filed within the 3 years from the date of accrual of the cause of action. He next submitted whether the oral evidence of the plaintiff has adduced are insufficient to declare the impugned deed of impugned partition deed as void in presence of sufficient documentary evidence. Oral evidence cannot be given weight. He relied on such and such judgment. Learned advocate for the defendant further submitted the suit is barred by law of limitation. It is not maintainable. Suit property has already been partitioned earlier by and between Gopeshwar Mollik and Narayan Mollik. So there is no scope to reopen the partition. So this suit is liable to be dismissed. Learned advocate for the plaintiff raises objection and submitted there is no limitation for filing a suit for partition. Though plaintiff sought for void declaration of the partition deed, but the main relief is for partition. If the main relief is not barred by limitation, the suit cannot be held to be the barred by limitation. When there are several reliefs claimed in the suit, the limitation period would be that of the main relief, and the limitation for ancillary relief is to be ignored. He relied upon judgment so and so, so and so. Next plot, paragraph court findings, paragraph page 220. Paragraph number 1. This is the court findings. Now this court is to say whether the suit is barred by law of limitation or bad for having the prior partition amongst the parties, or whether the impugned deed of partition is valid. Though it is alleged that the impugned deed of partition was fraudulently obtained by Gopeshwar by practicing undue influence, fraud, coercion, misrepresentation, but there is no clear-cut evidence in this behalf. Moreover, learned advocate for the defendant rightly pointed out that the plea of fraud and the coercion cannot coexist at the same time. Now, another aspect of the validity of the impugned deed is to be discussed. Partition can be effected either by partition suit or by the deed of partition. It is settled law that all co-sharers are necessary parties to suit for partition. The said principle is to be applicable in the deed of partition. Partition by deed is an arrangement made by the co-sharer to separate their unity and unity of possession as per their share, and even in the partition, one may relinquish his or her share in affected by all the co-sharer to the property in question, and therefore, if the partition deed is not accepted unanimously, such partition must fail. It will have to have no binding precedent on all co-sharer. Here, the suit Schedule A property of the plaintiff belongs to Indumoti Mollik and Naran Rokhit equally. Indumoti died in 1961, leaving behind her one son Gopeshwar and predeceased daughter, namely Lolita. This is the absolutely illegal findings because the Lolita's existence was not proved. Lolita was then presented by his two daughters named Kamala Rokhit and the Ostukona Rokhit. Admittedly, Kamala Rokhit and Ostukona Das are not the signatory, not unless until their mother, the existence of their mothers is admitted or the proof. The signature of their daughter is does not come. Signatory to the impugned deed of partition being numbered such and such exhibit B. Therefore, the impugned partition deed being numbered so and so, exhibit B has no binding upon Kamala Rokhit. Since deceased and Ostukona, since deceased, Durga Chakraborty is claiming through the Kamala Rokhit as per her daughter, as her daughter, and the pro forma defendant number 7A and 7A and 7B are claiming through their mother Ostukona Das. Therefore, the impugned deed of partition exhibit B has no binding effect upon the plaintiff.
So you say Kamala could claim only through Narayan?
Kamala,
as per your genealogical table, if you come back to that, page 94, Kamala could claim through Narayan.
Not only Narayan, some part from Narayan and some part from the Lolita. Kindly come to.
No, Lolita you are denying.
Yes, I am denying.
As per you, Kamala claims only through Narayan.
My lord.
And insofar as Ostukona is concerned, she does not get anything because her claim is through Lolita only.
Lolita only.
So Ostukona does not get anything, and Kamala claims through Narayan only his half share.
Yes.
All right.
So, Lord, when the learned judge has found there is no coercion, there is no fraud, there is no misrepresentation in the order impugned.
No, for non-joinder of all the co-sharers, that is the reason. Void held for that.
The non-joinder of the co-sharer and the existence of the Lolita was not proved, according to me.
But in any event, Kamala would be a necessary party.
Kamala is a party, Lord. Kamala.
To the partition deed?
Oh, yes, partition deed.
Partition deed was held to be void because Kamala and Ostukona did not sign.
Yes.
Now, even if Lolita is disowned, I mean, Lolita was not there. Might be Oshrukona's signature was not necessary.
No, Lord, because I am giving answer to my lord's query. Page 94, the 50% belongs to Indumoti, 50% belong to Narayan. Indumoti died, leaving behind my father as the only son. My
father is Gopeshwar.
Gopeshwar. So
yes.
the Gopeshwar was one of the one side in the
and
partition,
Narayan signed for
and Narayan was the second part.
All right. So if Lolita does not come in, Kamala and Ostukona does not come in at all.
My lord.
Because Kamala gets through Narayan only.
My lord.
If Narayan himself was a signatory, then there is no question of
grateful. And Lord, the Kamala.
Grateful together or different?
Yes. And Lord, the Kamala, gave her evidence in the cross-examination that she was all alone present on the date of registration of the partition deed. If this situation was there, her mother was one of the beneficiaries, or mother was one of the entitlement of mother is there, she could have raised the objection. And the evidence was brought on record. The suit property is absolutely divided.
Narayan and Gopeshwar were the only two signatories of the partition.
My lord.
Very well. Kamala need not have been a signatory there.
Kamala did not.
Narayan and Gopeshwar,
My
she
lord.
came to Narayan, if
Yes.
your case is correct.
According to my case.
So entire thing depends on Lolita's existence as a daughter of Indumati, being a co-sharer. Very well. And an additional point is that Kamala was present, so she is a stop brother in a sense.
Lord, Monday I will give a judgment on the point of limitation.
And what will you do today for the rest of the day? Ask.
Regarding this, Lord, here my learned friend has to answer. And Lord, my argument is over.
Achha, only the judgment.
Only the judgment. This is
Judgment
my
on which point?
Limitation point.
Limitation. Very well, yes.
A limitation point.
Yes.
So Mr. Kormukar is engaged in code number 5. A matter is going on. He just prayed that
Monday,
let it be on Monday.
Hard in part for further hearing on Monday. If you can, Mr. Ghosh, you just say to him in advance the judgment you will be citing, so that he can conclusively argue.
একটু নাম্বারটা একটু লিখে দিন, আমি দিয়ে দেবো।
আচ্ছা, এটাতে
Monday, I will check the LCR and the
check the LCR and whether you have to see whether it went down to the trial court for correction of the records. Or
Exhibit 19 and the deposition of the PW.
And whether it came back. Please ascertain. Engage your machinery. Yes. And Mr. Kormukar has to be ready on that date, otherwise you have to start immediately after he finishes. Come prepared in the matter. At least ask me, have a conference with Mr. Kormukar, learn the points. It may very well happen he will not be there when it is called on name, but you have to be ready.
Great.
Right.
My lord, I appear for the plaintiff decree holder, being the respondent. Other side, my lord,
Mr. Om Narayan Rai is appearing in this matter, my lord.
You start the matter. Then.
Briefed in this matter, my lord.
Yes.
My lord, I am also led by Mr. Shopang Subhasu. My lord, he's on his way.
But you are for the respondent,
I
you
am
are in
for
an
the
advantageous position. You are Mr.
My lord, Mr. Om Narayan Rai is appearing.
What is your name?
My lord, Ayush Sharma. My lord, I'm not briefed in this matter, my lord. My
Those are words here, I believe.
An adjournment is sought by the appellant. Let the matter stand adjourned for the day. Give your appearances, both of you, please. Not the seniors' appearances.
No, absolutely.
For the respondent, Tapos Chatterjee.
We hope you are for the appellant. Then you could have started. देखिए आगे कोन order पड़ा है.
Yes. Lots of very short points. That's why your lordship within 7 days given them the informal paper book.
Oh.
They have supplied me because
Just check
2G question of 2G.
Oh, that 2G.
Yes.
Yes. 2G.
Lordship, in
Start
this
2G.
matter, I am led by Mr. Tapos Bhattacharya, Lordship.
কেন আছে? আমরা বলেছিলাম কেন এটা অ্যাকশনে দিয়ে দাও। appeal along with. The matter, start the matter.
Lordship, according to Lordship, last order informal paper book have been prepared and Lordship, the paper book have been served also.
File it in court.
Lordship, it has been filed in the court on 7th.
It has been filed in court or in
No,
the
Lordship,
department?
in the department, Lordship. I am sorry, Lordship.
তাহলে একটুখানটা ওটা অনিন Let us start with the memorandum. Judgment on admission.
Lordship.
Yes.
No, extra copy.
You have an
No, Lordship. I was waiting for.
Mr. Bhattacharya, we are because you have filed in the department the paper books. We are asking for the paper books. We are trying to bring the paper books. In the meantime, we can start with the plaint and.
But I can give you one time.
No scratching of head.
But I know, madam. I know. It's my
Your head has been sufficiently scratched over the years. No further scratching.
But the only one day, madam. I know, my lord. Today,
What do you mean by only?
Candid confession, madam.
Confessions are always candid.
He forgot to hand over the paperwork to me, madam. But it's a candid.
Then he has to start. He will be penalized for that. He has to start with the paperwork. What is the point involved, Mr.
Order 12, Rule 6.
Yes, that much we also know from the previous order.
I know. Order 12, Rule 6.
What is the admission?
Admission, my lord. Yes, father died on 13 July 2016. And
suit is for what? Suit is for what?
Suit for eviction.
You filed eviction suit.
No.
Sorry, they filed eviction.
In 2021. The defense is that I paid the rent up to 2021. Thereafter, June, July, I sent the rent. By money, they refused it. There is a talk of that you give ask for demanded salami, rupees 10 lakhs. I am ready. Then we will accept your tenant after 5 years. Then I could not arrange for rupees 10 lakhs salary. Thereafter, sent a notice, my lord.
Paperwork is coming.
That is their stand. That is my stand, my lord. That is my defense. Since I admitted, I paid the rent up to 5 years. Thereafter, my lord, they refused to accept the rent from me. That's my admission. On the basis of that admission, they filed an appeal order 12 Rule 6. It is admitted.
But Mr. Bhattacharya, the relation, have you proved that you are have you pleaded that you are a dependent? Otherwise, in any event you go.
I have admitted.
If you admitted the relationship that you are the son or whatever, if
Yes,
you have not pleaded,
admitted.
If you have not pleaded that you are a dependent, then you go by under 2G in any event.
I have
Why should you
everything.
disturb?
Only question is,
reasons may be wrong, but the conclusion is correct then.
But kindly see my admission. Kindly see my admission. Did you also kindly see now?
You have not annexed the plaint and written statement in the stay application.
Yes, I have annexed. Annexed.
Where?
Statement order page 1 to 10, plain. The paper book.
Paper book is coming.
Yes.
You have got a copy of the paper. Let us start
Yes.
with your paper.
Yes.
Yes, thank you. Yes. I'll take there. We will take there. Oh, we need two copies. Yes. Let us start with the print.
Now, can you see written statement? Written statement, you also can you see? Written statement, my lord. Page 12, inner page 2.
Ranjan Ghosh was the father.
Yes.
Original tenant.
Yes. But can you page 10, page 12?
Yes, we are there only. We are at page 12 only.
Oh, yes, sir. That before dealing with the several paragraphs of the plaint, the defendant likes to ventilate the following facts which are very much essential for adjudication of the instance suit. That all material trial Ranjan Ghosh was the sole tenant in respect of the suit premises of suit tenancy. The said Ranjan Ghosh died on 30 July 2016, leaving behind the defendant as his legal heir and legal representative. That after death of said Ranjan Ghosh, the plaintiff met with the defendant at his flat, the suit tenancy. And thereafter the plaintiff amicably agreed and he admitted The defendant is a tenant under him and he directed the defendant to pay rent in respect of the flat tenancy rupees 1700 per month, and accordingly, as per the direction of the plaintiff, the defendant paid rent till May 2021 at the rate of rupees 1700 per month by money order, and those money orders are accepted by the plaintiff as the rent in respect of the suit premises or flat. But unfortunately, in spite of valid tender of the rent for the month of June 2021 and July 2021, upon the plaintiff by the defendant through postal money order, the rent for the month of June 2021 and July 2021 were returned to the defendant. It is pertinent to mention that in the middle of July 2018, the plaintiff came to the defendant's flat and demanded a sum of his rent only as a salami from the defendant for issuance of rent bills in favor of him for the period on or after the death of defendant's father. Rental amount will be such and such, which are already accepted by the plaintiff from the defendant. However, the defendant could not arrange the same at a time. The defendant was compelled to express his ability to pay some of his 10 lakh as salami to the plaintiff, though his dependent expresses to enhance the rent at a marketable price, and he was willing to pay the enhanced rate of the rent as per provision of law and as per the marketable value. Then, my lord, this is my admission. Then you will also can see their application. My written objection also, my can say page 28 to 30.
Need not be.
No, but application.
Yes.
2022.
Yes.
Page 20.
Right.
And that, as you can see, paragraph 3, my lord. Start of paragraph 3. Further, the defendant, Ranjan Ghosh, was a recorded tenant under the plaintiff in respect of one self-contained flat, such and such, consisting of 2 rooms, 1 hall, 1 kitchen, and 2 bathrooms.
Sir, Bhattacharya, you have no defense. Even if you are a dependent, after 5 years, you go. So, Tata, goodbye. Judgment is correct. We
Only, but I am citing only one decision. Only one decision.
I cite your decision, but
one. বইটা দাও ওইখানে বইটা আছে
ডিপেন্ডেন্ট হলো 5 বছর বাদে ওই যা বললাম
মানে the
adieu alvida whatever
only order to receive, but that's my satisfaction. Only I know my
law is very clear. You know much better than us because you are the advocate for the appellant. Yes, for judgment.
Paragraph 22.
22. These appeals are pending for years, Mr. Bhattacharya. No, you are not. You have done your duty as well.
It's my duty, Maru.
Absolutely, absolutely. Oh no, this is pending only. This is current. So bad luck.
Correct.
The appeal is 2024.
Remember last week, application post he was moved. You also.
Yes. Which paragraph? Sorry.
Paragraph 22.
22.
An admission in pleading means a statement by a party to the legal proceedings, whether oral, documentary, or content, in an electronic form, and the said statement suggests an inference with respect to fact, a fact issue between the parties or a relevant fact. It is axiomatic that to constitute an admission, the said statement must be clear, unequivocal, and ought not to entertain a different view. Coming to the admission in pleading, these are averment made by a party in the pleading, plain it is statement, etc. In a pending proceeding of the admitting the factual matrix presented by the other side, to constitute a valid admission in pleading, said admission should be unequivocal, unconditional, and unambiguous. And the admission must be made with an intention to be bound by it. Admission must be valid without being proved by adducing evidence and enabling the opposite party to succeed without trial. A court, while pronouncing a judgment on admission, keeps in perspective requirements in Order 7, Rule 5, 8, Rule 5, Order 12, Rule 6, and Order 15, Rules 1 and 2 CPC, read with Section 17, 58, and 68 of the Inner Evidence Act. Then, my lord, paragraph 36. What is the valuable right? If a judgment is passed on the basis of that admission, Order 12 rules is, my valuable right will go. But that is page 36.
Para.
The above analysis, but that is on the basis of the will probate. The above analysis would clearly show that there is no exhibit marked with or without objection, much less a categorical admission. It is unequivocally clear to us that the plaintiffs defendant 1, defendant 3 in no uncertain terms state their views on the will. What is admitted by the defendant 4 is not an admission in the case of plaintiff. It is at best a statement in continuation of what has been pleaded in paragraph 24 to 27 of the written statement. Appreciation and acceptance of the above pleading or response to the admission or denial as warning a judgment on admission is presently erroneous. We have in the preceding paragraph noted the learned single judge, after taking note of the objection to the pronouncement of the judgment admission and after doubting the existence of such and still satisfied.
Have any of you got a copy of the 97 Act? Premises Act 97? We may go against you, so let him.
Yeah.
Will it be morally correct to rely on your book to dismiss your appeal?
I know it's a law. What does that mean? But that is
on the law. We'll have to quote that.
One thing more, my right of
We'll take the book. Yes.
defense,
Right of defense. Yes.
my right of appeal,
Right of appeal.
my right of appeal have been affected, but without taking evidence. On the basis of that unequivocal, and so that statement is very, I have a right of appeal also. I will lose. That is my submission before lawsuit. But there is a clear admission. There is a talk of that is settlement. We shall issue a rent receipt. If you pay,
Talk of grant of a new tenancy. Yes, that you have pleaded.
That is, I have pleaded. That is only my submission. Nothing. That is why I am only.
But no pleading of new tenancy having been created.
No, nothing. Then my lord, that paragraph 37 also, but is a if you lost it, page 383, that paragraph 37 also.
37.
Can you see? I am reading the learned. The matter is what is such a late behind such and such a the succession to the suit for whether intestate testimony would be the principal issue of adjudication. Principal issue of adjudication. We record that the impugned judgment interpret the clause such and such has not proved such and such. Then the judgment or admission is an illegal exercise discretionary jurisdiction under order 12 rule 6 related to such and such. The case on hand in our considered view, present the tribal issue in facts and law. For arriving such a view, also take note that categorical realities are learned in such and such and such. The clients are not accepting the existence such and such. But that is my submission before lawsuit. I have admitted my father died to such and such. I have admitted they accepted the rent from such and such. But in between 2018, they said talk, but we shall accept your tenant provided you pay salami rupees and we are ready to pay the enhanced rent. That is my submission before us. That is my submission. On this basis, my lord, the almost Supreme Court, recent judgment, my lord, my lord, that matter was ordered set aside, remanded back to dispose of the suit within a time was fixed 4 months. On the basis that
poor trial judge.
Trial judge.
Poor trial judge. Suffered for.
That is my issue. And one other day when I submitted before the Supreme Court judgment, that judgment is not valid because in that judgment, possibly your losses gone through that judgment, 1956 Act, who died in the night before coming to force 97 Act.
It's in regular newspapers also.
Then that judgment is not helpful.
Not retrospect. That is not applicable to you.
That is not. That is why I did not cite that. I am not citing that judgment. Only that.
This took place after the act taking into effect. So
only that. There is no evidence, nothing, always clear admission. This other pleading also there. But I could not prove whether there's a talk of the as well if you pay salami such and such, such and such. So I pleading. Otherwise, I know my lord order 2G also I know.
They've heard you.
Sorry, I have placed that judgment also, this I have gone through this recent judgment, this judgment.
No, thank you very much. I mean, it's absolutely relevant, but maybe does not help you.
Yes.
The present appeal has been preferred by the defendant in an eviction suit. Full stop. Next para. by the impugned judgment, comma, the learned trial judge has proceeded on the premise that in view of the pleadings in the written statement of the defendant stroke appellant, comma, the defendant comes within the purview of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997, and as such, comma, after the lapse of the moratorium period of 5 years subsequent to the demise of his father, comma, the original tenant, comma, the status of the defendant was relegated to that of a mere trespasser. Full stop. Next para. Accordingly, a judgment on admission has been passed. Full stop. Next para. Learned counsel appearing for the appellant contends that the purported admission, comma, to qualify as an admission, double inverted admission, to qualify as an admission for the purpose of Order 12, Rule 6 of the Code of Civil Procedure being attracted, comma, ought to be unambiguous and unqualified. Full stop. Next para. In support of such proposition, comma, learned counsel cites Vikrant Kapila and another versus Pankaja Panda and others. Reported at 2024 within bracket 2 ICC 364 within bracket SC. Full stop. Next para. It is argued that in the written statement, comma, the defendant categorically stated that the plaintiff stroke landlord was into an ongoing talk of grant of a fresh tenancy in favor of the defendant. Full stop. In fact, comma, even after the demise of the original tenant, comma, the father of the defendant, comma, the landlord stroke plaintiff continued to accept rent from the defendant for a further period, comma, which according to the defendant stroke appellant, comma, indicates the intention of the plaintiff to create a new tenancy by treating the defendant as a tenant. Full stop. Next para. It is thus argued that without granting an opportunity to the defendant to lead evidence on the above aspects of the defense case, comma, the learned trial judge erred in law in passing a judgment on admission outright, comma, which is premature and precluded the defense case from being corroborated by cogent evidence. For sub next para. Learned counsel for the respondent controverts such arguments and points out that the learned trial judge looked into the defense case and as per the pleadings of the written statement, comma, the judgment on admission was justified. Push up next para. Upon hearing learned counsel for the parties and considering the materials of the case, comma, we are at one with the learned trial judge for the following reasons, colon, niche. As held by the Supreme Court in the cited judgment of Vikrant Kapila Supra, comma, there cannot be any quarrel with the proposition that in order for a court to pass a judgment on admission under Order 12, Rule 6 of the Code of Civil Procedure, comma, the admission in question is required to be unqualified. Push up next para. In the facts of the case, comma, we find from the statements made in the written statement that certain ingredients were categorically admitted by the defendant in the written statement. First up, the demise of the original tenant admittedly took place on July 13, 2016. First up, it is further admitted by the defendant in his written statement that the landlord stroke plaintiff took rent from the defendant till the month of May, 2021, that is roughly up to 5 years after the expiry of the moratorium period from the demise of the original tenant, as stipulated in section 2 within bracket small g of the 1997 Act. Full stop. Those are the only ingredients which are required to be looked into for the purpose of satisfying the requirement of section 2 within bracket small g of the 1997 Act. Full stop. The said provision is quoted herein below. এই বইটা থেকে না, ব্র্যাকেটে জি টু লিখে ডেফিনিশন করে এইটুকুনি দিয়ে তারপর ততটা তারপর জি বলে জিতে যা আছে পুরোটা শেষ। Next para. According to the said clause, comma, the dependent heir of the original tenant, comma, unless the widow of the original tenant, comma, is entitled to carry on as a tenant within bracket coming within the definition of double inverted tenant as defined in section 2 within bracket small g bracket closed, comma, to continue in such capacity for a period of 5 years from the demise of the original tenant. Full stop. Next para. Hence, comma, although the defendant has not pleaded in his written statement that he was a dependent of the original tenant, comma, which would further cut short his period of tenancy, comma, proceeding on the premise that the defendant was a dependent, comma, even then he, comma, being the son of the original tenant, comma, would be entitled to sustain his tenancy in such capacity only up to the expiry of a period of 5 years from the demise of the original tenant. Full stop. Next para. From the pleadings in the written statement, comma, it is evident that the said period is already over, comma, since the original tenant, comma, his father Ranjan Ghosh, met his demise on July 13, 2016. Full stop. Next para. It is further admitted in the written statement that the landlord stroke plaintiff, comma, quite rightly, comma, stopped accepting rent from the defendant after May 2021. That is, after the expiry of the said period of 5 years from the expiry of the original landlord. Full stop. Next para. Hence, comma, the pleadings in the written statement comprise of sufficient ingredients to bring the defendant within the fold of section 2 within bracket small g of the 1997 Act. Full stop. Next para. It may be clarified here that it is well settled that law or legal arguments need not be pleaded in the pleadings, comma, either by way of a plaint or a written statement. Full stop. Next para. As such, comma, the defendant need not have pleaded the applicability of section 2 within bracket small g of the 1997 Act or even take it in, of the 1997 Act for the purpose of the pleading to acquire the character of an admission for the purpose of Order 12, Rule 6 of the Code. Full stop. It would suffice, comma, as in the present case, comma, if the necessary factual ingredients to satisfy section 2 within bracket small g are pleaded in the written statement, comma, for it to be deemed to be an admission that the defendant comes within the purview of section 2 within bracket small g. Full stop. Next para. That is precisely the case here. Full stop. Next para. In the event the defendant comes within section 2 within bracket small g of the 1997 Act, comma, nothing remains in the suit, comma, since the defendant is automatically relegated to the status of a trespasser and the plaintiff automatically becomes entitled to get a decree for eviction in the absence of any further or independent right having been claimed by the defendant. Full stop. Next para. The defendant, comma, in the written statement, comma, claims entirely through his father, comma, the original tenant, full stop. The pleading as to there being a talk of a fresh tenancy being granted in favor of the defendant is neither here nor there, comma, since even the said pleading does not tantamount to a new tenancy having already been created in favor of the defendant, comma, in which case the outcome of the litigation might have been otherwise. Full stop. Next para, as such, comma, the learned trial judge was fully justified in resorting to section 2 within bracket small g of the 1997 Act, read with order 12 rule 6 of the Code of Civil Procedure, to come to the finding that the plaintiff automatically gets entitled to a decree for eviction by way of a judgment on admission. Full stop. Next para. In such view of the matter, comma, we do not find any justification to interfere with the impugned judgment and decree. Full stop. Accordingly, FAT 7 of 2024 is dismissed on contest, comma, thereby affirming the judgment and decree dated December 2, 2023, passed by the learned judge, comma, 5th bench, comma, City Civil Court at Calcutta, comma, District Calcutta, entitled suit number 1068 of 2021. Full stop. There will be no address to cost. Full stop. Keeping in view the pendency of the appeal for so long, comma, the respondent, the appellant, the defendant stroke appellant is granted a further period of 3 months to vacate the premises in favor of the plaintiff stroke respondent.
When appeal of
Execution case,
24,
execution case is pending. my lord.
not recent appeal.
And
Not
police
over.
has
So
filed-
the pending execution case shall remain stayed for such period, full stop. In the event the plaintiff, the defendant appellant does not vacate the premises within the said period of 3 months from this date, comma, the plaintiff, decree holder, plaintiff stroke decree holder will be at liberty to proceed with the execution case, and the same will be expedited by the executing court.
And interim order stands pending.
Hey,
Interim order, if any, stands vacated.
Yes.
May I get the paper book?
Yes.
Paperbooks have come. তাহলে এগুলো ফেরত দিন।
Justice Jyotirmoy Bhaji told me, in another matter, we may not start to lose, but that judgment will help me in another matter also.
Yes, definitely.
Justice Bhattacharya, judge,
আমাদের 97 একটা কোনো আছে প্রেমিসিস সিনিস 1990 Yes, sure.
Oh,
For expedition. But
What is the
against, my lord,
this is an appeal against?
it's not an appeal, this is a 227 application against for expedition with an LRTT.
We have determination.
Mind
very
of-
well.
it's been assigned to
acha.
mine.
Oh, by only for the entire thing is for that. Acha.
And the entire thing is for that. However, when I mentioned it for listing, I asked for leave that I may serve because it might, I have done so.
Yes.
But
No, what is the stage there before the?
I filed. It was listed after a month and a half. They came and said, we have no instructions. I asked for an interim order, which was not granted, but I'm not challenging that here. I said, very well, allow them to file an affidavit in opposition and hear out the matter. He said, no, I will not direct them to file an affidavit in opposition now. I will first ask for a report. And only after I get the report.
Report regarding what?
Exactly. My lord will see the impugned order. I said, I will ask for a report. Only thereafter will I ask for an affidavit in opposition. And the date was fixed 8 months later for filing a report. And there is a simple point of law involved. There are 2 points. One, the BLLRO is refusing to comply with the order passed by the collector. I'd asked, let the record of rights be corrected in terms of the order passed by the collector, which he is not doing. That's the interim order I asked for, an interim order, which he said, no, let me get a report. And the other one was totally on a point of law, settled by the division bench, settled by the High Court, settled by the Supreme Court.
What should be a reasonable period?
My lord, the reasonable period is, my lord, same order by a coordinate bench, identical order will serve my purpose. Same facts. Even here, he asked for a report.
Same person, maybe.
But I don't
but
want
there
to...
the state was represented. You have given a notice, no?
I have given a notice, but then I understand the notice has been served yesterday. I said, but I've also served the GP.
Notice is not required in these expedition matters.
Very well, but no, because all I'm asking for is that the time to file an affidavit in opposition be fixed by this court.
Yes, yes, we'll do that.
Very well. Yeah, I've got no problem. And my lord,
direct you to serve a server copy of this order on the state.
Very well.
So that will suffice to ensure compliance.
Very well. The matter is fixed on in January. We will come back. We will go before the court in January after completion of affidavits.
But unless the date is preponed, they cannot file their affidavit because in the tribunal they have to do it on the date fixed, not like this court.
I mean, let him give me an advance copy. I mean, let him file it.
What is the next date fixed? Let us see.
The date has been fixed on the 8th of January. In July, it was fixed in January.
We'll direct them to file their opposition on that date and give an advance copy to you on the returnable date, and we'll fix 4 months time from that period to conclude.
Not 4 months. I will take 2 weeks to file my reply, and let him dispose of within a month of the next date.
Within a month, maybe. What is the scope of that your challenge? Only that, whatever you said.
Very limited. It's a solely a point of law. Like the thing is, I asked for correction. They said very well. Instead of correction, they told me to apply for release.
Correction on the premise of some deed of yours.
No. The thing is, under the Act, under the Estate Acquisition Act, only non-agricultural tenancies. This didn't apply to non-agricultural tenancies. Mine was a non-agricultural tenancies much below the limit.
Yes.
So I became a riot under the state directly. This point was argued in very many matters. Obijiti, which has just been disposed of in the Supreme Court, and it says it does not apply. So I asked for a correction of an entry in that section, that this premises is covered by section 6.3. That's all. And I asked for correction. The correction order, my lord will see it, page 65. The collector has passed an order directing correction. The BLRO refuses to comply.
Where will pass an order? In view of the innocuous nature of the order proposed to be passed, no prior service of notice on the respondent state is insisted upon.
And though it is served, and I can.
But you did not pass any direction that was of your own.
I asked my lord, may I serve? My lord said, give a notice. But there's no. It's not minuted, of course. I have served, but the service says that it is to be listed yesterday and to be taken up as and when called, which is what is happening.
It was a hand service or what?
It's been served by race post, by speed post. I've got the track report.
We cannot take note of that. We
very well don't take note of that.
Next paragraph. Learned counsel appearing for the petitioner points out that the proceeding pending before the West Bengal Land Reforms and Tenancy Tribunal has been kept pending for an inordinate period, next para, by placing the order dated July 19, 2024, it is contended that the matter has been unnecessarily relegated to January 8, 2025, that is about 4.5 months after the date of such order,
and more than 6 months. Man, it was filed in July.
4.5
months from today. And for filing a
6.5 months. That is about 6.5 months from the date of passing of the order, on the specious ground that a status report is required to be obtained. First of next para, upon a perusal of the annexed certified copy and the averments in the application, we are convinced that the matter ought to be directed to be disposed of at an early date. First up, next para, accordingly, CO LRT 3 of 2024 is disposed of by requesting the
Mallet is not disposing of, very well.
disposing of
I request the second bench.
the yes, this is a second yes by requesting the second bench, West Bengal Land Reforms and Tenancy Tribunal to dispose of the
OA 1608
pending application of the petitioner bearing OA number 1608 of 2024 within bracket LRTT bracket closed by the end of March 2025. First up, next para, the affidavit in opposition to the said application shall be filed before the LRTT on the next returnable date, that is on January 8, 2025, by the respondent state upon service of advance copy of the same on the learned advocate on record appearing for the petitioner before the tribunal. First up, next para, reply, if any, thereto shall be filed within a week thereafter.
Give me 2 weeks.
2 weeks.
He'll get it.
Then it cannot be March, then it will be April.
Very well. I'll file it
Within
within a week. I'll file
within
it.
a week thereafter. Full stop. Next para, it is made clear that the merits of the contentions before the tribunal are not gone into by this court, and it will be open to the tribunal to decide on all issues independently and in accordance with law. First up, the learned advocate on record for the petitioner shall communicate a server copy of this order at the earliest on the respondents and stroke or the learned advocate appearing for the respondents before the tribunal.
Madam, one indulgence. Yes. May this order be communicated by the department to the LRTT.
We'll say that the tribunal will act on your communication. Otherwise, we shall.
My lord, it doesn't happen. My lord,
But that will take more
I
time.
went my just
That will
indicate.
take more time. I will direct that.
My lord, I will in any case do it. But
Very well.
he says, well, the retired officers, he says, oh, he take umbrage because I don't address him as my lord. He's an administrative officer. My lord will see the order sheet. He says, I'm honorable Mr. Justice something.
We are entitled to our own idiosyncrasies. Tolma একটা line add করে দাও. This order be communicated immediately to the tribunal through the department of this court.
I'm obliged.
এটা ফেরত দিন। এটা যেটা দিয়েছিলেন এটা ফেরত দিন। Thank you. না ওটা ফেরত দিতেন, ওটা রেফার করে দিন।